Lordship, Lordship, may I permit to mention, my Lordship? My Lordship, host has been started now, and my Lordship, may I?
Yes, একটু থেমে যান আপনি
My Lordship, I'm audible.
Yes, what is your matter, madam?
My Lordship, I am mentioning it from Circuit Bench Alipurduar. My Lordship, it has been heard by me that if during the off circuit matter can be taken by principal bench. My Lordship, I have one matter, matter related to electricity disconnection. My Lordship, WBSDSL matter which has been pending before the circuit bench since 2024.
Circuit bench is available today.
My Lordship, today available, but today is last day, my Lordship. Circuit bench will not take, and this matter has been pending.
Today you cannot, therefore today you cannot mention. The bench is available today.
My Lordship, may I mention on Monday, my Lordship? Today is last day.
If it is not taken up today, please mention on Monday.
Yes.
Yes.
Lordship, this is an application.
This writ petition seeks expeditious disposal of an application under section 14. আচ্ছা সব ডিস্ট্রিক্ট ম্যাজিস্ট্রেট নাম ফাম চেঞ্জ হলে সবকটাতে চেঞ্জ করবেন, শুধু লাস্টেরটা চেঞ্জ করবেন না, নাহলে আবার আমাকে সব দেখতে হবে, কারণ সেম ম্যাটার হলে চেঞ্জ হবে কিছু কিছু জায়গায়। এটা একটু ভালো করে টাইপ করে নিন, তাহলে আপনার বাকিগুলো ঠিক বুঝতে পারবেন। Of an application under section 14 of the securitization and reconstruction of
Item number 3, my lord, similar matter, similar prayer, my lord.
date of application
22nd August 2025, my lord.
August 20I remember, Mr. Chakravarti. Yes. For
6 June 2020.
fourth state is not there. এখানে ওখানে state is represented যেখানে লিখেছেন item number 4 এ none appears for the state. Where is your affidavit of service?
Lordship.
সবই সেম থাকবে, none appears for the state, আর যেখানে লিখেছেন having heard the learned advocates appearing for the respective parties সেখানে লিখবেন having heard the learned advocate appearing for the petitioner, কারণ স্টেট তো নেই। আচ্ছা 8. None appears for the respondents.
Here for the state.
7. এটাও পশ্চিম মেদিনীপুর। Date
27th January 2025.
27 January 2025. State represented আছে। হ্যাঁ, same. Next.
Great. Item number 10, my lord, Purvo
10 matter time for the state.
10 state represented.
September
None
24.
for the private
2020.
respondent. হ্যাঁ, state is represented, none for the private respondent. এটা সবকটাতে none for the private respondent থাকছি, আর যেখানে none appears মানে তো none appears for the respondent। আর এটা হচ্ছে পূর্ব মেদিনীপুর। পূর্ব মেদিনীপুর
Purvo Medinipur, my lord, September 24, 2025.
24 September 2020 2025।
Petitioner. Very peculiar circumstance.
Bank, may I pray for 5 minutes pass over?
Fast over।
5.
Lordship.
Item number 11.
Yes.
Lordship, item number 11, your lordship, I'm appearing for the state. May I pray for a very short passover, your lordship? The instructions have come to me, your lordship.
All
There is
right.
another card.
Pass over. Come
Matter,
back.
your lordship.
Passing it over. Come back.
Lordship, grateful, my lord. Grateful,
Pass
my
over.
lord.
Next.
My lord, I appeal on behalf of
12, I am for the my lord, petitioner, my lord. My lord, I have served, my lord, the affidavit service is
Yes,
not affirmed,
yes.
my lord. My lord,
You affirm it in course of this
yes,
day.
my lord,
File.
Xerox copy is with me, my lord.
Not required.
File.
File the original. I will not
File,
take Xerox.
file,
File the original. Affirm it during the
my
day
lord,
service.
file. My lord,
Yes.
what has happened, my lord, in this writ petition, I have challenged your lordship's order dated 22nd July 2026. My lord, in that writ petition, I was not a party. My lord, in that writ petition, your lordship has directed the complaint of the petitioner was who is the private respondent here in my lord. My lord, the complaint was that the some persons who were added as a private respondent in that writ petition were obstructing. So for that reason, your lordship was pleased to direct the licensee authority to effect a connection and to take assistance of the police station, Satragachi police station. My lord, what has happened, my lord, the petitioner, the private respondent is trying to take his connection through a land in which we are the co-sharer. My lord, that aspect was not brought into the notice of your lordship. But for that reason, lordship may kindly seize the petitioner the private respondent filed a title suit. In that title suit, the police submitted a report. And in that report also, my lord, may kindly look at the report at page 81.
Page 81.
81, my lord.
Yes.
Well, this is the report of the Inspector of Police OC Satragachi PS dated 12 January 2026.
Hmm.
May I please, my lord? With due respect, I beg to report that in compliance to the order of learned court noted above, the undersigned with other visited the site locally on 18 December 25 at such and such RS Dak number 4510 corresponding LR Dak number 5037. In presence of the petitioner Kobirul Islam Sardar and the OP persons and other local residents, on physical verification, it is found there is a Dhalai road from Moukhali Nimtala road started at Bokapara, ended at the doorstep of the petitioner through the mohalla called Zakir Basti, and there is underground cable line of CSC to that point. On the other hand, the petitioner wants to take correction of electricity from a point at Golabari site where from his land so purchased from the OP persons, and there is a common land of so many shareholders showing as road by the petitioner. The so-called road as per petitioner is found an open land beside a ditch and not a path at all. The distance of this disputed stretch is about 15 to 20 feet, is actually a common land, and the OP person have objection in such electric connection due to the bitter relationship. In order of the learned court dated 14 November 2025, there is no direction mentioned from which side the connection will be taken, and the position of the house of the petitioner and the land in question adjacent to that house is located in a junction of the two mohallas away from the locality. Well, thereafter, the next paragraph, the last sentence, as mentioned above, there is an alternative and viable undisputed route available to his house, and the said plot from Zakir Basti side with connection point to CSC. So, my lord, there is an undisputed route, and my lord, only one.
There is an undisputed plot.
This is the police report, my lord. My lord, no.
Whatever it is.
My lord, kindly come to page number 123. That is the impugned order. And I don't know whether, my
My
lord,
lord, before that,
your
my
lordship's
lord,
order can be challenged before your lordship or not.
It is not the question of challenging the.
Kindly come,
my
my
lord,
lord.
my lord. So, regarding this mental ability aspect, my lord,
I am not
that
said
can be
regarding maintenance.
no, my lord, my senior friend has just said whether your lordship can be challenged by way of a writ petition before your lordship. My lord, to that aspect, may I place only one judgment? My lord, this is a special bench judgment.
I have not challenged the maintenance.
My lord, paragraph 46, my lordship may kindly cease.
Review is permissible in by way of a separate writ.
Yes, my lord.
Settled, I know that.
My lord.
Justice Dotto's judgment is there after
My lord.
this,
My lord.
isn't it?
My lord. And my lord, another judgment, my lord, this is a coordinate bench judgment. My lord, if there is any objection raised from any plot owner regarding electricity connection, my lord, the only recourse that is available to the licensing authority is my.
At this juncture, I will not disconnect the line which has been.
No, he has no. Connection has not been affected, my lord.
They have,
not yet been
No, tomorrow it
they
is
have
going
not
to be
allowed.
affected.
They have not allowed us, my lord, to do it. Even nor even the
So why
police.
don't you take the alternate route? If the
If
alternate
my lord directs, my lord, we will, my lord.
why not? I did not say that you have to barge in somebody's property.
No, my
I
lord. The difficulty is that, my learned friend, who is appearing for the petitioner today, was not there before your lordship when the order
Yes.
was passed on 22nd.
Yes.
This
Which
is
is
a
why
paid
even-
case. This is a paid case, where we submitted that we went for giving the.
Who is appearing for the petitioner in the earlier writ petition? You are appearing. If there is an alternative way for you to get electricity, you want electricity supply. You don't want it through his house. So let it happen that way, Mr. Mukherjee.
Then we'll keep it returnable. We'll come up with a report.
Come up with a report, because if there is an alternative pathway.
Yes. If
then
there is an alternative path, and if
otherwise, I will direct in terms of Chandu Khamaru. I will direct electricity to be supplied to him. And in the meantime, you approach the DM and get it sorted.
Mine.
But then he cannot be without electricity in the meantime. That is what Chandu Khamaru has said.
Mine.
Right?
Mine.
He will get electricity supplied through the passage available now.
Mine.
till such time that the dispute is resolved. That arrangement will continue as an interim arrangement, and the district magistrate, in terms of section 67 of the Act and Rule 3 of the licensees rules,
2006 rules.
will, yes, 2006 rules will find out a way.
So kindly, my lord, make it returnable in the next week.
No, my lord will give me fortnight's time.
No, he is
My lord,
without
my lord,
electricity.
my lord, my lord, this will
1
take
week. 1 week
my
will do.
lord, 10 days. 10 days. My lord, before puja, my lord, it's very difficult.
Pujas are almost 2 months back now, Mr. I mean 2 months away.
My
Mr.
10
Mukherjee.
days. 10
Let
days.
us not have that fervor now, please.
10 days.
7
My lord,
7 days.
it's a request.
You can twist it forward.
Maybe 2-3 more days.
দিয়ে দিন এটা ওর ভেতরে রেখে দিন।
There was a passed over matter, item number 4. I was appearing for the state, my lord. Item number 4
Item 4 you are appearing Samar
for the state.
passed over নয়, item 4 has been disposed of.
It has
ওনার
been-
নামটা
I'm grateful.
Item number 9 also.
item 9 you are appearing for the
Must
state.
be- my-
Give your name and write it.
my,
ওই
my-
যারা যারা নাম দিচ্ছে ওখানে নানা পিয়ার্সটাকে কেটে দেবেন।
I'm grateful, your
Give your name and item number. সমরদা নানা পিয়ার্স
11 is my petition, my lord.
for the state কেটে দেবেন যারা যারা নাম দিচ্ছে। Yes.
11 is my petition, my lord. My lord, the petitioners are the registered third-party owners who are in actual possession. The bank now seeks to dispossess us pursuant to a section 14 proceedings. The order passed by the learned CMM in 2019 in a proceedings which was initiated admittedly in 2015. And obviously the property was mortgaged prior to that. We do not know.
Lordship, I'm praying for the respondent state.
Yes, madam, I have passed it over. I have
Item
recalled.
number 11,
Yes.
My lord, kindly comes to the impugned notice
Yes.
at annexure P3 at page 208.
208.
It is little illegible. Got the typed copy at page 209. Lordship may kindly see the notice is dated 12th August 26 from State Bank of India, and it was pasted on the premises on 13th August 26. It says, addressed to Reform Ferro Cast Private Limited and Measure Siland Developers Private Limited as corporate guarantor, address 32A such and such, subject request for vacating the mortgaged property in the account of Measures Reform Ferro Cast Private Limited borrower and Measure Siland Developer Private Limited corporate guarantor, mortgaged with the State Bank of India Stressed Assets Management Branch 2. Dear sir, madam, this is to inform you that the learned Chief Judicial Magistrate Calcutta is going to take peaceful physical possession of your mortgaged property in the account of Measures Reform Ferrocast Private Limited borrower and Measure Silent Developers Private Limited on 17th August 26. Deed number such and such, all that demarcated western portion of the premises number 32A, Mahendra Simani Street in the above town of Kolkata, contained in a piece of land measuring about an area of 3 katha 4 chathak, with the same a little more or less together with a 2-storied structure. My lord, this is important. 2-storied structure standing thereon, measuring 1,000 square feet, 500 square feet each floor, be the same, a little more or less at Amar Street, PS, ward number 35, butted and bounded in the manner hereunder by north such and such, by east such and such. The property stands in the name of Measure Silent Developers Private Limited. You are requested to make necessary arrangement to remove your entire articles, stock of goods, cash, jewelry, valuables from your mortgage property. And with,
read it.
yes, my lord, in my humble submission, this property no longer exists as it has been stated now. Why I am saying so, my lord? I'll give a little background of the property. The property originally belonged to one Robindranath Chaudhary.
Why don't you go to the DRT? It's a section 14 notice that you are challenging.
It's a section
14 order that you are challenging. You have your
Yes.
remedy before the DRT.
But I do not have a single document in my hand.
This is sufficient. This order is sufficient. Whatever you have annexed before the
Lordship,
court,
kindly seize one of my prayer. Kindly seize my prayer in the writ petition.
I will direct the DRT to expedite hearing. Go before the DRT, get it heard, because that is the remedy that is available.
Lordship, kindly, why I'm saying, kindly cease my prayer. G.
Yes.
That is exactly what I prayed.
Yes, I am granting you that.
And in the meantime, kindly restrain them.
If I say that you have an alternative remedy, I cannot stay at the same time.
No.
Because there is a bar. Once I say that I will not exercise jurisdiction
Yes.
or discretion because of availability of alternative remedy, in the
Then
same breath, I
Lordship will
cannot
not be able
injunct.
to give me an interim protection.
Yes.
And that's why I am saying,
So that is why your first approach should have been to go there and
But I-
obtain stay.
I do not have that time.
Why?
Because the DRT system, as its Lordship knows it very well. The system
Forgotten.
system as it stands now, even if I file today, diary number, verification, I will get the first date after 7 days.
Put up.
Even with put up, my lord. That is the system what is happening.
I've seen it happening same day also. Happens.
Yes, but that
Like you did it here.
here it is possible,
filed it
there it is
yesterday,
impossible.
You got it heard today.
My lord, I will also rely upon, if so far as the alternative remedy is concerned, I will rely upon that Whirlpool judgment.
Whirlpool is well settled.
Yes.
But there are several others thereafter taking into consideration Whirlpool, the latest recruit to the long line of judgments.
No, my lord, my submission is, now since I will prefer this writ on another aspect also.
Are you going to take possession tomorrow?
Today.
Lordship will,
That's why I am,
not only on the maintainability, there are other grounds which Lordship's considerations require. Because we are taking the possession now. The possession is.
Lordship,
If they are innocent borrowers, third party purchasers with
Lordship
value
will
without notice.
Look at their full title deed. Lordship will take up the first title deed.
Lordship kindly says how it has followed, how the title has come. One Rabindranath Chaudhary was the owner of the property. That Rabindranath Chaudhary was the owner of the entire 32 Mahendra Singh Mani Road. He sold it to two persons, Madan Gopal Shah and Bhogirath Shah in 1957. Bhogirath died. Thereafter, the legal heirs of Bhogirath and Madan partitioned the suit amongst themselves, property amongst themselves, and it got two plots, 32A and 32B. 32A is now that 3 Katha 4 Chathak, what they are saying. That property was gifted by Madan to his two sons, Shumit and Shantanu. This Shumit and Shantanu sold it on 31st March 2009 to Silent Developers, whose name Lordship is finding here. That Silent Developers sold the property, 3 Katha 4 Chathak land and a 2-storied building on 21st January 2016 to one Dr. Ashim Kumar Das. 2015, the magistrate's order says that already section 14 is initiated. But 2016, this sale takes place. My deed,
That doesn't matter.
my deed says that has been sold without encumbrance.
That is because of the mischief of the vendor.
Now,
For that, the bank can't be faulted.
this Ashim Kumar Das had thereafter constructed a G+3 multi-storied building.
That is accrual on the mortgage.
In
How
which
will that
this property
give you a better right? The property has been mortgaged.
we do not know.
Yes.
We do not know.
That is what you don't know. But since the bank has enforced
Bank
the
is
mortgage,
claiming it is mortgaged.
it is seeking to enforce the mortgage, and Section 14 order has been passed. Prima facie, there is a mortgage. Otherwise, Section 14
My lord,
order, the
kindly say-
9-point affidavit would include this.
My lord,
If
kindly.
the magistrate,
That's why I'm saying, my lord, kindly sees the annexure P2 at page 206.
page 206, yes.
This is the report of Central Registry of Securitization Assets. On 13th August Kindly sees when it was generated, 13th August, the day first came. Kindly turns the,
Not there.
no match found.
It's there. It is there. I am carrying the print. And not only that, Lordship, there is
Certify registration is not there, it will be difficult.
certified registration is there.
Let us see.
And not only that, Lordship, all the actions have been taken by the bank prior to the mandatory, the introduction of the mandatoriness or the bindingness of the certified registration. It was given effect, Lordship will, and not only that, the State Bank.
It's a data based. It's a data based. It's an asset based.
Charge holder.
This report which my learned friend has handed up now is data based.
Data based report.
And kindly sees the report I have generated, which is annexed at page 206,
Searched it.
asset-based search report.
You have searched it asset based. You should have
Yes,
searched.
because
If you have searched it database, you have found it, because this is, if it is equitably mortgaged with the bank, it is not a case of no CERSAI registration at all. If you have
my lord,
put the particulars, you have to search it always, in all the ways possible. If you search it in one way possible and leave the other ways, then you cannot fault.
but then
find fault
this
with the bank.
particular asset is not mortgaged.
Of course it is.
My lord,
Of course it is. The search is data based. It is not that the CERSAI registration is not there. How you are entering into the search is something which is mentioned there. It does not mean that the property has not been registered on the CERSAI registration portal.
Not only that, Lordship will kindly take up the 26, the Part 4A of the SARFAESI Act that was inserted by an amendment in
2016.
2016, effective
which was
2020.
which was given effect on 24th of January 2020. The learned CMM court's order is in 30th of January 2019, and that is merely being implemented pursuant to your Lordship's direction passed in another writ petition. These are the
If
two
there
orders.
was a writ
Lordship.
petition, when I do not know when was the writ petition filed, then that writ petition also do not, I am not a privy to that writ petition, not a party to it.
Will not be.
The sale of their purported vendor is in 2016. The 13-2 was in 2014. 13 operates as soon as 13-2 is issued. Lordships knows that.
My lord, I am the bona fide,
Of the property.
I am a bona fide purchaser. Kindly seize my purchase deeds. Kindly deeds my purchase deeds. Each of the 8 flat owners have purchased it, paying 40 lakhs, 35 lakhs from
What
2019
is
to
the amount due, madam?
Lordship, the amount I don't have, as per the 13-2, it is, I think, more than 100. 107 crores 15 lakh something as on 2014.
107 crores, my entire property will not be valued even more than 2 crores.
That is not the issue. I was thinking of something.
Lordship will
So,
also look into the
This 8 flat owners as on today's date, what will they be remediless completely? I'm asking myself.
When was this notice served?
13th August.
You could have approached the DRT in the meantime.
I could not have approached.
Why not? 13th August. Today we are on
13th August was a
21st August.
Friday. 5th, I think 14th, 15th was Saturday,
On
Sunday.
13th itself you could have gone.
My lord,
You could have
except
generated
this
it, filed it.
document, I do not have anything.
You don't need to have anything. The manner in which you have approached this court, in the same manner you could have approached the DRT also.
My lord, kindly allows me to go to DRT and gives me limited protection of 1 week.
Limited protection I cannot give you in view of the Semji Rungta
But
judgment.
then I will be remediless. Then
You chose to be that, because why did you wait for 7 days then?
my lord,
You could have
going
come.
to DRT,
If this is the notice which gave you time for 7 days, you could have charted out your remedies, planned out your remedies accordingly. Why did you choose such a forum where there is risk?
my lord,
It is very difficult now.
alternative
If I was unaware of the judgment, I had not gone through it, I would have passed the order as we always do.
no.
But
It's
MG
not a
Rungta,
question of that.
1952 Supreme Court, taken care of by the Honorable Supreme Court again in February 2026, reiterating this, that once you say that there is an alternative remedy, you absolutely wash off your hands. You cannot injunct. Yes, you cannot injunct. Now, in this, I mean, in view of this kind of strict command by the Honorable Supreme Court, how can I take a
But then
different view?
if they are taking possession today, my entire effort will be infructuous.
Can we not hold for a few days?
Lordship will kindly appreciate that this is the order is already being executed today. Lordship, we will-
2019 till 2026.
Lordship will kindly sees that
I purchased in
are the
2020.
petitioners, what are the relief sprayed? What they in a
If they are flat owners and they are unaware, they will be thrown out of the property without having a remedy, without having their.
any event.
I understand
their
legally
purchase,
they do
Lordship
not have.
Lordship will kindly look into
Since
this
they have
and
waited for so many years, for a few more, they may get it rejected before the DRT, but till such time that they file it, I will not be able to pass an order of injunction. But I can see if the bank agrees and gives them some time, since they have already waited
Lordship,
for
my
this.
instruction is that they're taking possession in course of the day.
They are supposed to take, that's what they said, but my clients are here. They are saying that it is not yet initiated.
But prima facie case has to be made out, Lordship.
Lordship,
will
Lordship,
not
one
constrain
another,
the bank.
I have said I will not. I'm just trying
Another
to find out
aspect.
a midway if the bank agrees.
Another aspect. Some of the purchasers who are petitioners before Lordship had taken their own personal loans. Banks made searches. Bank of India, Axis Bank, Union Bank of India. Those banks I have made parties. They did not find anything.
Neither here nor there.
So
They might not have searched it properly.
that
If
is but,
document is shown,
but
if a
then
document,
as a bona fide purchaser, as I am repeating, as a bona fide purchaser for value, how do I know that the property which is getting developed and being constructed a G+3 multi-storied building comprising 9-10 flats would know that the property is mortgaged by some unscrupulous element?
Lordship will
And Lordship kindly says, what is my protection if I do not get any documents?
that argument is not cutting ice at all, because
Yes.
whatever document you have,
That is not related to me.
whatever document you have before you with you for approaching the writ court, the same documents you could have employed for approaching the DRT also. So you need not have 13-2 notice, 13-4 notice, and possession notice for you to approach the DRT. If you have one page, that is sufficient. The document with which you are aggrieved, that will suffice for you to approach the DRT and get a required relief.
Visualize this.
I have visualized. That is why I am saying you could have
2019
approached there. Now you have wasted 7 days. You have put the court also in an embarrassing situation because of this kind of relief being sought.
2019 order, 2015 CMM initiation, as the order itself shows.
Whatever it is.
2019 they got the order. Now I purchased the properties in 2019, 2020. If they were diligent enough, bank, this situation would not have arisen.
Who knows? Because it is because of them, or because
bank
of the state
has
authorities.
allowed this situation to come.
Very well. You are also partly responsible. You can't.
I am responsible for last 5 days.
No. You are responsible for carrying a wrong search in the Sarsai.
I have purchased it from my bank loan.
So
if
what?
I am purchasing
So
it
what?
from bank loan, then
Therefore your due diligence is not
Lordship
required.
kindly says when the
Because you purchase it through bank, your due diligence is not required.
I do not know whether this report will
That can
reflect.
be a good ground for you to fight out the bank, saying that no, I will not repay the loan to you because you have done your own search. But
Wait.
that will not.
No, I'm not making that submission, my lord.
No, you said that the bank has searched. That is why I said.
When was this entered in the search?
Lordship will take up the third page. It was entered on 12/4/2011. As it was.
No, it could not have been because Sarsai itself was not there. That time.
Sarshai was there. The mandate, the
It was not made mandatory.
Yes,
It was not made mandatory. Sarsai
So,
came
my lord,
sometime in 2006-7.
This kindly sees this column. I am, with all respect to my senior learned friend, SI creation date in bank. This is security interest creation in bank, not the entry date.
And
Whatever it is.
Thereafter, the next line.
SI registration stamp in Sarsai portal.
Yes.
So
This was done in 2011, in July 2011.
now, my lord, if my lender itself does not, they are also nationalized banks.
That gives you a cause of action against your lender, but that does not give you a cause of action against the bank which has a mortgageable right. Sorry, a
My lord,
security
my
interest
cause
in
of
respect-
action will come against my learned friend's client because learned friend's client was not.
Your cause of action against the bank here, the respondent here, will arise for the respondent's fault. What is the fault of the respondent here? You show me that.
Respondents,
Because I will be able to injunct them if you can show that they are at fault. Sarsai registration, prima facie they have done. Section 14, they have obtained order. If the order has not been implemented, it is not for their fault. The order has not been implemented because of the inaction of the police. For that, they have to.
for what?
Yes.
They were not diligent enough.
No, they have approached the High Court. That is what was
When they
the
approached
submission.
the High Court, my lord. Now, when they approach the High Court, they must have seen the property nature
Whatever
and
it is,
character
they are
of
not
the
required
property.
to do all that. They have the property,
My
they
lord,
have the title
the
deeds, they
nature
will-
and character of the property has
Mr.
changed.
This becomes difficult.
No, the nature and property of the
Mukherjee, the nature of the property will not help.
nature of the property has completely changed, my lord.
Whatever it is.
There is no mortgage of.
If there is accretion, please see section 69, what it says. That is not something which you can claim. It will be
There
between
is
the- it
there
will
is
be
no
between the
individual
mortgager and
mortgage
the
of my flats. There are no individual mortgages of my flat.
Not required.
Today,
Not required.
today,
Your flat is on the same building.
that building does not
Even
exist.
then, all these points do not make their action so illegal that 226 will be invoked despite an alternative remedy being available.
My lord kindly appreciates where.
I'm appreciating, that is why I'm hearing so long. Otherwise, in
No,
5
no,
minutes.
that like lordship always gives us that indulgence. We are so grateful for that.
Lordship, we are appearing for the respondent state, your lordship. We are under a direction to provide police assistance as and when the possession is taken. So if we are intimated today at what time the possession will be taken,
Lordship,
we shall be rendering the police
kindly
assistance.
protect me for a limited period so that I can approach the appropriate forum
Lordship will kindly,
and directs them to give me the
Let
documents.
me hear her now. I've heard you. Yes.
Lordship will kindly, since Lordship knows, I'm just placing as a matter of repetition, paragraph 32 of transcode. Now,
That is the scheme of the act, that even if they lose possession,
that it is in the nature of an attachment. Now, Lordship will kindly appreciate that the 13(2) was in 2014. This is in 2014. Now, Lordship will kindly look into the recital of their own deed, which starts from page 27. Lordship will kindly look into page 32.
is 32.
Lordship will kindly look into that. And whereas the deed of sale dated 31st day of March 2009, this is the concerned deed which is mortgaged with the bank. Lordship will get that particulars from the 13(2) itself. At the second page, Lordship will kindly look into the 13(2) notice. The second page, this is the self-same deed 3151 of 2009 in the name of silent developer. Now, from silent developer has agreed to sell the aforesaid property in favor of Dr. Ashim Kumar Das, and accordingly deed of sale dated 21st day of January 2016. So admittedly, it is after the measure of the 13(2) being issued, this deed has been executed. So there is no title has accrued in favor of their vendor. So today they do not have a prima facie title in the property. The property, the 13(2) measures were initiated, 13 for possession notice was issued, and the prayer before the learned CMM court was also made prior to this date in 2016. Now, Lordship will kindly look into their representation at The last page, Lordship, the page 212 stated on close scrutiny of a notice, it is revealed that the order of the learned court was passed on 31/2019, which is more than 6 years from now, and if State Bank would at least provide intimation that property in question is hypothecated to the State Bank by flaunting a hoarding in the premises, in that case, all the flat owners would not have suffered to this extent as we are facing now. But there was gross negligence on their part to carry out the job in proper manner, for which we are being harassed and suffered. And most importantly, if we being evicted, then who will compensate us for no faults? So there are cases of a compensation. They make a representation before the bank that who will compensate. Please submit. And now Lordship will kindly look into their prayers in the writ petition. For seeking a writ of mandamus, there has to be a right. They pray for directions upon the bank to provide copies of the loan documents and other concerned documents, and a limited protection for not taking possession without making out a prima facie case. The certiorari registration, Lordship, I have furnished the concerned document to show that there was a certiorari registration. Even if it was not there, my measures were completed. The order of these learned CMM was passed in 2019, before the chapter 4 was also given effect to. But I still stand on a better footing because my certiorari registration was.
How many flats are there in this building?
Lordship, the petitioners before your Lordship.
8 petitioners,
8.
5 flats. 5 flat owners are there.
And how many flats are there in total?
6 flats are there.
Only.
G plus 3. G plus 3.
Says they are at best victims of a fraud which has been practiced, but no fault on my part. Lordship, we kindly appreciate that there is no fault on the part of the bank. There is no averment why they have not.
Can you take instructions from the bank if they can stay their hands for 2-3 days so that they can approach TRT at least?
Lordship, I will come back, but the moment Lordships interfere in, then
It's not a question of interfering. I just wanted to know if they can do so, because they have waited for so long. If they can wait for 1 or 2 days, 2 or 3 days, I'll direct the DRT to immediately take it up without passing any formal order of injunction. But if you see the bank can do it, then in that case, at least they could have their say before the forum concerned.
Lordship, but still the prima facie case has.
I understand all of this, but you understand the plight also, because looking at it from the lens of the person who has purchased it, having done whatever was on the surface required, take instructions if you can and come back and tell me at 2.
Lordship, the possession will be taken in the meantime.
Lordship,
Then
there's
12.
direction at 1 p.m.
12. Half an hour.
Yes. Half an hour's time, may I come back with the instruction?
Today is
But
Friday. So kindly gives me time till next Friday.
I cannot give you time because
I
of
will
MP
request my
Rupta. Yes.
Friend,
If I had the authority to give you time, I would have done it. Since I am conscious, therefore I cannot.
I will come back with instructions that morning I had.
Tell them to be a little
Lordship,
understanding in these situations, because I can understand the bank is not at fault, but I can also understand that prima facie they are also not at fault.
to apply.
So, let us see if we can balance the equities. Law is definitely in your favor. Your actions, I cannot say that are illegal, at least prima facie. But they should have some forum where they can ventilate their grievances.
I completely bow down to your Lordship. I've
Come back
taken
at 12.
instructions in the morning. I think I am already told that the
Tell them that if they can consider this.
Lordship, in that event,
ask-
your Lordship, at 12, your Lordship, because the instruction given on the police
at
was
1 p.m.
for 1 p.m., then we'll also restrain ourselves from
Not at 12. It's at 1 p.m.
1.
12টায় একবার ডাকবেন। ফিক্সড ম্যাটারের আগে একবার ডেকে দেবেন।
Oblige me. This is very rampant now. Very rampant.
But item number 13, I'm praying for a week's accommodation.
What is the matter?
The restoration application been dismissed at 25th of August 2025.
The explanation you don't want.
The application was not served.
Oh,
That is why praying for a week's accommodation. By that time, we'll serve the copy.
এটা not this week করে দিন, next week এ দিয়ে দেন।
Great.
Under item number 14, I'm praying for not today, my lord.
Yeah, I just assist my friend, my lord. She wants a not today, but my lord, it's a contempt application against the block land and land reforms officer, Bhagwanpur 2. But they have wrongly, my lord, mentioned the name of the BDO instead. So, my lord, they need to correct the name of the.
New incumbent has joined, my lord.
No, it's not a case of a new incumbent.
Very well. In any case, it will be changed.
Yeah, it has to be changed. So, your lordship may
Whatever
give.
reason for new incumbent or for the
Yes,
change of
yes,
the
your lordship.
Course of the day, we will correct that name, my lord.
লিখে দিন।
The
Within course of the day, we'll file the affidavit.
Just a
of
minute.
service also.
Mr. Lakmani, learned advocate appearing for the state authorities, submits that the name of the alleged contemner has been wrongly mentioned. Full stop. It is submitted that while the alleged contemner is the block land and land reforms officer,
Bhagwanpur 2.
Bhagwanpur 2, comma, the name that has been mentioned in the application for contempt is that of the block development
X.
officer,
X block.
is that of the erstwhile block development officer, is that of the erstwhile block development officer of Bhagwanpur 2 block. Full stop. Paragraph. Learned advocate appearing for the petitioner seeks leave of the court to correct the name of the alleged contemner.
Within course
Full
of
stop. Such leave is granted. Let such correction be done in course of this day. A copy of the contempt application shall be served upon the alleged contemner after amending the cause title of the contempt application, comma, within a week from date. List this matter on 11th September
within
2026.
course of the day, I will file the affidavit of service also, my lord.
Affidavit of service will not do because according to him and according to you also. So you correct the name and serve afresh, and the matter will be listed on 11th September.
My lord, if they may, my lord, I may make it easy for them. If she can just hand it over to me. I have instructions, my lord, to appear.
I will ওখানে লিখে দিন alleged contemner as well as Mr. Lakmani.
Grateful. I'll try, my lord, see if this can be complied with. Unnecessary contempt.
Next.
My lord, I am also on behalf of the state, learned additional government pleader, Mrs. Indrani Chakraborty, in this matter, with the learned junior, Mr. Lachman.
I'll lead her, my lord. He wants a name to be given, I've given him.
Very good. Next. Item 15.
15 and 16, my lord, Mr. D.K. Monto, appear on behalf of the petitioner, praying for not this wing due to illness.
My lord, in this matter, my lord, we are praying for 3 weeks time, my lord. For compliance, my lord,
16 both. 15 and 16 both.
16টা লিখে দিন, শুধু ওই নিচেরটা থাকবে না। 16 you are not appearing.
Both the
Same order. 15, 16 same order.
Application first time.
What is the order?
Order my lord, as a direction to the concerned subdivision officer, application order Tomlu. Kindly see the page 23. Page 23, 12, my lord.
Page?
Page 23.
Page 23.
Order of the operating portion, my lord.
Yes.
The court is therefore directed to the subdivisional officer Tomluk Irrigation Subdivision, that is response number 4, to consider the petition representation and take appropriate steps in accordance with law if the said authority finds that the allegation labeled by the petitioner is meritorious. Then the response number 4 shall initiate proceeding under the relevant statute, including the West Bengal Public Land Eviction and Unauthorized Occupants Act 1962, and ensure the completion thereof in accordance with law. It is clarified that if any proceeding for eviction and removal of the encroachment over the government land is initiated, all interested party, including the petitioner and the respondent number 10 and 11, shall be permitted to state their respective cases before the subdivision. Sir, it's according to law before the final decision. Well, 14 my lord, is a specific time, my lord, page 24. Para 14, needless to mention that if any proceeding for eviction of the removal encroachment initiated under any act or statute that shall be concluded according to the law within a period of 12 weeks from the first date of
This
the
is an application for contempt.
এই তো লাস্টেরটা annexed P6 তাই তো না এটা কেন হবে? হ্যাঁ এটাতে কার সন্ন্যাস আসছে In the same plot, similar order has been passed by the coordinator bench. In the same plot. So my responsible submission by virtue of that no public harm is there. My submission is the public policy will not be attracted in the instant case. I am not the all the cases, I mean not the instant case. My responsible submission there the interest of the petitioner only to demarcate so that the royalty property can be saved. This is the only.
Mr. Gupta, what is your problem in getting it demarcated?
I'll definitely, since it is falling from your lordship, I need to satisfy your lordship's conscience of that. But kindly see, kindly see that paragraph 19. Possibly this is not the right case to go for the petition.
I'm not going by technically.
Not on the technical, even on the pleading that the representation was not annexed. That is the pleading. Kindly see, my lord, this is page 71. The representation is after the order.
No, that is earlier repetition, not earlier repetition.
This is after the order. Dated 2nd of May 2020.
Mr. Maiti.
কোনটা তুমি দেখাচ্ছ কোনটা দেখাচ্ছ হ্যাঁ repetition earlier repetition was not annexed.
How could it be annexed, Mr. Maiti? Earlier writ petition was withdrawn on 11th August 2021. The representation has been made on May 2,
Representation was made, but in the writ petition was.
Where is that? Why has it
previous writ petition also?
Where is that? In this writ petition, if the earlier writ petition was withdrawn because of non-annexation of the representation.
That order has not been indicated. I am submitting.
I understand order was not indicated. I am assuming your best case to be the true case. Now that representation should have been annexed to this writ petition also. Where is that representation here? This representation is after that order. This could not have been the representation for which you withdrew.
My lord, that my lord, the fresh representation was made.
Where is the? This cannot be the ground then. If it was only for non-appending the representation, Mr. Maiti, that representation should have been annexed saying that yes, this
after the withdrawal, fresh representation was made.
Before the withdrawal, the representation which was made, that was the ground for you to withdraw. So that representation should have been annexed. You could have annexed a later representation also. There is no quarrel with that. But so far as the earlier
that is also lacuna in the sense, my lord, since the order itself not indicated that on the grounds of representation or annexed.
That is order may not have indicated. If your pleading is there, you should have annexed the representation to support your pleadings.
That has not been. Since the latest representation.
Then how will I believe your case? On what basis will I believe your case? You don't have the representation. Order does not show that. The representation is subsequent to the order. How will I believe your case? Tell me.
ভাষাটা ল্যাঙ্গুয়েজটাকে রিপ্রেজেন্টেশন অ্যানেক্স করেনি
The case has to show something for me to believe the court. I mean, believe the case.
I do understand, my lord, the things for a moment.
Because your order does not say that you are withdrawing with leave. Your petition says. Order does not say that it is being withdrawn to file afresh with better particulars because the representation was not there. Your petition says. Then your petition does not have the representation.
My lord, I beg to apology, my lord. My submission, otherwise, my lord, the representation was not made. The writ application was filed. That's why the fresh representation made.
No, you are writing. Please see, you are again not right. But unfortunately, the representation not annexed in 2021.
Not annexed. That is wrongly printed. That has been wrongly plained in the wrongly manner.
Sir Maiti, now this becomes.
But apart from that, my lord, this representation has not been considered at all in the earlier representation. And apart from that, this representation has not been considered or not taken into account at the earlier petition.
My lord,
if it is so.
my lord, I would beseech your lordship to dismiss this on the maintainability, but I will satisfy your lordship's conscience otherwise. Kindly takes the report filed on behalf of HITCO, where we have indicated it has already been demarcated. I'll otherwise try and satisfy your lordship's conscience.
Yes.
Now, kindly turns to the second page, paragraph 5.
Report on behalf of 3 and 4.
Yes.
I mean, I am not there. I am in doubt, my lord, only how the apparate of for demarcation. If my payment cost, my client is interested to pay the cost. My lord, this demarcation, what is the wrong in it?
Was acquired in part for an area of 0.95 acres out of the total plot area was 1.42 acres. Now, my lord, your lordship would kindly have a look at the possession certificates, which is, my lord, annexure A, which starts from, my lord, page 6.
Page 6.
Page 6, my lord, are all the notifications under, my lord, section 17(4).
Oh, that is not challenged. There is no challenge question.
And, my lord,
That
the
is not
possession has
challenge.
been taken.
Yeah.
Now, my lord, your lordship would kindly have a look at, my lord, paragraph 7.
That
Not
was not
different-
challenged.
was fine.
Paragraph 7 of your
Paragraph
report.
7.
Yes.
But a different writ petition was filed by a different plot owner of the same plot of land, Kashinath Nayak. But in such and such, Kashinath Nayak, his predecessor in title. Honorable Justice such and such was pleased to pass an order dated such and such directing the land acquisition collector to cause physical demarcation of the land. It was also directed by the court that once the demarcation is made, the writ petitioner will be at liberty to construct. Then at his own cost for physical. Then the direction for verification of the plot 139 was given. Now, my lord, will kindly turn to the annexure where the report is there for the physical verification. Kindly see page 17, my lord, demarcation. The report is done.
17.
Page 7. In compliance with the order passed by Honorable Justice on 10th September 2015 in such and such, then, my lord, the last sentence, the writ petitioner himself was present at the time of demarcation at 12:30 p.m. Mr. Such and such Assistant Land Acquisition Officer, Sri Such and such Surveyor of the office were present with me, and Sri Such and such, both surveyors were also present on behalf of HITCO for the demarcation work. The demarcation of RS plot 139 showing the acquired portion and the non-acquired portion separately was made up to the satisfaction of the writ petitioner in compliance with the order of the Honorable Court. Map showing field position marking acquired portion with yellow color and non-acquired portion with pink color is prepared and enclosed. Kindly turns to the map, my lord, page, my lord, 18. So, my lord, here is the demarcation map of this entire plot, my lord, 139. Where yellow is, my lord, the acquired and the pink is non-acquired. So, demarcation already done. The prayers are already satisfied. Now, my lord.
He is claiming in respect of which dag? 139.
139. Plot is one, same plot.
139. Now, my lord, your lordship would kindly turn
139 was demarcated in Kashinath Nayak's case only.
Yes, my respectful submission, in 130 plot 139, several plot owners are there. They have come before this honorable court time to time. On their order, they have demarcated. My respectful submission, when my land has been enclosed, I come before this court. I only prayer for, I only.
Paragraph 6 of the writ petition, the petitioner has pleaded that he has purchased it from Kashinath Nayak.
Of course. Nothing.
Purchase, then Kashinath's demarcation was already done.
My lord, the only things for me. Let me finish.
Demarcated
Let me
plot
finish.
of the unacquired portion.
Let me finish.
Yes, Mr.
Now, my lord, the report also has, my lord, we have also annexed, my lord, an application for demarcation of the adjoining plot owners, which are abutting 139. Your lordship would kindly have a look at the report once, my lord. Page 19.
Page
19. I had shown, my lord, page
90.
Page 19, my lord.
19.
Yes.
Yes.
So, my lord, even the surrounding plots are also, my lord, demarcated pursuant to order passed in another writ petition. So, my lord, it cannot be the case also. We did this to show that, my lord, it is not only within 139, but so that he cannot complain that others from other plots it is being encroached upon. That is also not done, because that is also demarcated. That your lordship would find in page 90, the report. So your lordship would kindly now have a look at the map at page 21. Your lordship would find this is regarding 165 and 166. My lord, why this is relevant? Your lordship would kindly have a look at the map once, my lord.
The earlier one.
Yes, the earlier map, my lord.
Yes.
Page 17.
Yes.
Notification
Yes.
No, my lord, we had annexed this on the basis of the averment that the other lands have also not been demarcated. So it's not the abutting land, but otherwise also in that area it has been demarcated. So whatever acquired portion is there in that entire area has already been demarcated.
Mr. Maiti, you have purchased from Kashinath Naik.
My lord,
Just let me complete once.
Yes.
You have purchased from Kashinath Naik. Kashinath Naik's plot has been demarcated.
Kasinath plot has not demarcated.
Yes, that was the order. Justice Arijit Banerjee's order is there.
My lord, that if it is demarcated, then I should not come before this
Yes,
court.
that is what.
My responsibility, if it is
Oh,
demarcated, how they problem? How they, my client is interested to make payment.
Mr. Maiti, the Justice Banerjee's order is for demarcation of Kashinath Naik's plot. That was what was placed just now.
This as order has been indicated in terms of the order, no demarcation has been held. That is the problem. Thereafter,
Order has not been complied
with. Thereafter, my client has purchased the land.
Incorrect, and if they were aggrieved by that, they should have
My
preferred.
responsibility,
Now,
no
this
question
is
of contempt. I am the subsequent
to save the
purchaser.
limitation
I am
for
suffering this portion. My lord, what is the prevention is there? My lord, if it is demarcated, there should be fresh demarcation done. In my cost, what is the objection to that? What is the problem?
I object, my lord. This
My cost is payment. My
they come and do this, my lord. This has already been done way back. So this
That should
petition
be-
should go.
When did you purchase?
my lord, I purchased the annex the documents. Annex the
Purchase a demarcated plot.
That's true. New question of that. After that, my lord,
Show me your purchase date. Show me.
now this is 2011, 21st January 2011.
You have purchased in
No,
2011.
sorry. Sorry. Second, it took time. বিক্রেতা সদস্য This is annexure P3, kindly see.
Page.
And page 52. This was the agreement for sale.
Just a minute. No, agreement for sale will not do. Where is your conveyance?
And that is not yet been convinced since demarcation has not been held. That is the case. And apart from that, other plots is there.
Then where is your right to move the writ petition?
My
to another
responsibility,
right?
submission, my right.
Mr. Maiti, if you have not yet purchased the plot,
Not only
then you
that,
must focus standard
not
also.
only this plot. I have the annex document, annexure P1. I have the another portion of the plot.
Which another portion?
That is the second 21st January 2011. This is also deed, and these I have purchased the land. Not Kasinath. Kasinath, one plot is under sale for agreement was held only for Kasinath.
Yes, Mr. Gupta, the other plot?
We are concerned with plot 139. Entire 139 has been demarcated into acquired portion and unacquired portion. So, my lord, it may so happen that in the unacquired portions there may be 100 owners, but the demarcation.
He says you have encroached. Where is the case that he has encroached? Show me from the writ petition.
That's why come before this court. If it is not
Where
encroached,
is
that is the allegation, my lord.
You cannot just hold the authorities responsible for demarcating your private plots. You have to show that he has encroached. Where is that allegation?
My lord, page 72, second paragraph.
Page
72, page second paragraph. My representation. Second and third paragraph.
The case of, my lord, an eviction, not a demarcation. If your lordship goes by the second paragraph,
Second and third paragraph.
there is a case of eviction suit. Then
No question of eviction. So
no, but if you have encroached upon
that has
being
been done
in the
because
name of acquiring, if you have encroached upon, he can come up in writ
it was
also.
done way back.
He will not be sent to suit court.
But this was done way back because in the report, my lord, we had indicated exactly, my lord, the boundary lines in the presence of Kashinath Nayak. Everybody were there. The land department people were there in paragraph page 17 and 18. So, but after this, nothing remains in
What is his exception to the report?
exception. No,
He has not taken any exception to the report.
no, nobody has ever taken. Everybody.
No, the report that you have filed in the form of affidavit, to that he has not
No.
filed any exception.
No,
No order was there.
I do not know. my lord. They have also not. Okay, I do not know. I'll.
exception file হয়নি হয়েছে
No, I have an exception. Yes. Now, there is an exception file.
What is their case in the exception?
exception file আমার কাছে কপি নেই তো
Has your lordship got it? The exception. May I hand up my copy?
না আমার কাছেও কপি নেই
May I hand up my copy?
যদি এখানে exception কোথায় গেল?
Kindly says nothing. He's saying my plot has not been demarcated.
that's with my interest to the my plot only I cannot say
Mr. Maiti, second paragraph of your exception damages your case. You say that they have demarcated acquired and unacquired. If your case falls within unacquired, then it is demarcated. Now, within the unacquired, separate demarcations, again, they are not responsible to do that.
question is my lord
Problem with other
minute.
co-owner of,
My lord,
of
the-
the some other plot.
my
He
lord,
wants us.
question is arises
report to do
plot
that.
is same question is arises my lord plot is same no separate plot plot of 139 only portion of the plot my lord has been acquired and portion has not been acquired the several persons my lord the right owners my lord I annex the document annexer P6
Sir,
that is
Maiti,
parliament
I am not satisfied with this. This exception, you could have made out that case. Encroachment case is also not made out here.
my lord if it is my lord the demarcation well, I cannot understand my lord my client interested to make the payment the cost for demarcation how they have afraid of
Right of the petitioner.
Right of the petition, that's true.
Cannot be because the respondent is afraid of. He has to show
That is true.
a legal right. This is a dispute in
But
all
Mr.
likelihood
Mr.
between his
Gupta,
co-owners.
if he is willing to pay costs, why are you not once more demarcated?
It has already been may I indicate?
What?
The unacquired portion may have 100 owners. Now it is not the job.
Not 100 owners, only I.
No, his case is of encroachment also.
It is,
that you have
we have already demarcated to the satisfaction of his predecessor.
When I was not.
No challenge.
When
to
my
that.
client was not.
10 years, there is no challenge to that report. No other plot owner has come up. He may have a dispute with any other co-owner of
he
an
has
adjacent plot.
He has annexed report. He has annexed an order where in other case also your report was not found to be proper by this court. Page 68 of the writ petition.
No, but we have carried out. That is why, my lord, I had placed the other one also.
First time demarcation.
That is first time demarcation. After that, my lord, this was done. After that, my lord, Justice Banerjee, my lord, order was done, which was
No,
carried out.
this is subsequent to Justice Banerjee's
That is why, my lord, I had placed the other one, my lord, page 19.
Page
Justice
68,
Ghosh.
Page 68 is 2022 order.
Yes, so that is why after that, my lord, your lordship would kindly see page 19 of my report. Justice Shubhra Ghosh's order, my lord. Demarcation carried out after that, that's a different plot of land, my lord.
That is, my client was not there. My client was not there. My respectful submission,
What the writ petitioner has alleged is a different plot of land.
no different
So
plot,
that is
same plot,
we have
no
paragraph
different
14
plot.
is a different plot of land in the writ petition. So, my lord, we have dealt with that in the report.
And the inquiry be
You
conducted by the
satisfied
block
that
and
also.
land reform officer.
Very well, I have a fixed matter at 12. We'll take it next week.
I have taken instructions. The bank was initially scheduled to take the possession on 17th. 17th, the petitioners had approached the bank and they had in fact submitted this letter also requesting them not to take possession. Bank had restrained itself on 17th. So
This is the letter which is annexed.
no, this is a different letter, it seems. There are 2 pages letter. This was submitted on 17th of August, Lordship. They had requested the bank not to take possession on that date. Bank had even approached the police station. Police was also ready to give assistance on that date. They had sought for some time. So the bank has rescheduled it to this date, Lordship. Lordship, the bank is, today bank is not inclined to restrain themselves, Lordship. The difficulty being the order is almost in 2019, we had to also obtain an order from your Lordships for enforcement of that order. Now we have got all the police costs and everything has been paid, Lordships. So today the bank is not inclined to restrain itself, Lordship. The last, they have sought for some reasonable time to settle on the issue. Lordship will kindly look into the, and also again in this letter, they have stated that who will compensate us for no faults. So it is a question of their compensation and they have already requested the bank on 17. They could have very well approached the Debts Recovery Tribunal, which they have chosen not to, Lordship. So Lordship will kindly.
About this, why did you give this letter then? You should have approached the DRT.
If
It becomes difficult for the writ court to intervene now.
Lordship, in that case, I will make some submissions, certain submissions. First of all, my learned friend has also submitted, and it is apparent on the face of the record that a humongous fraud has been committed upon the writ petitioners.
That is not for this court to comment upon now. If fraud has been committed by you, it has not been committed by this bank. It has been committed by somebody else.
That's number one. Number two,
you have to avail your remedies against that person who has committed fraud.
Number two, once the fraud has been committed on the persons who are ordinary,
who has committed the fraud.
The fact remains the fraud has been committed upon the ordinary citizens of the country, citizens of the country who are the writ petitioners before Lordship and who are law-abiding citizens.
Will only waste time because these submissions are not submissions in law. I understand you have to make submissions to show that this is one such case where alternative remedy can be bypassed.
Number one.
That submission, because this is not that submission. You have to fall within one of the 4 exceptions that has been carved out.
I'll come
to show that the bank has done something which the bank could not have done. And when you are speaking about the bank, you are speaking about that bank whose section 14 action you are challenging before this court.
Number one, that the ordinary citizens are before Lordship in a Article 226 to protect their rightful interest in the property. Number one. Number two, these ordinary citizens, when they purchase the property, they have done all that they could have done. Number three, my learned friends has shown today, placed on record, that the asset-based search of Sarsai report, but debtor-based search of Sarsai report. But when I purchase the property, I do not know who would be the debtors. I will always make search.
Not required to feed the name of the debtor.
How do I know? How would I know?
Not required. That is the purpose of Sarsai. The purpose of Sarsai is only to see whether there is a debt created in respect of the property or not.
If I do not know the name of the debtors, then I cannot make that search. I will always make the search.
Whom you are purchasing, you will definitely have. If
that person is not the debtor, my lord.
Silent developer is the debtor.
I have not purchased from Silent.
Your deed mentions the name.
Silent has sold it to X, and from X I have purchased it.
Therefore, you ought to have gone that far and checked it up. For that, you cannot fault the bank now.
And then, when I make the asset-based search, nothing comes out.
You have to show that the mortgage is deficient. That does not turn out to be in the facts of this case.
Fourth point, what exactly was secured asset in 2014-15 when they got the order from the CGM's court? is no longer remains the asset now.
TP Act আছে, Transfer of Property Act ছিল না আমাদের?
Possibly section 69 will not, does not protect that. Section, in 2014-15, they got the order of a two-storied building. Today, that building is G+3 with 6 individual ownership and flats. Who are the bona fide purchasers? They had got these properties, purchased these properties by taking the bank loans. These are nationalized banks who conducted their own searches and found nothing. They were satisfied about the marketability, title and marketability of the property and allowed the loan to proceed.
Please see section 70 of the Transfer of Property Act. Please see section 70. You take my book.
After the date of mortgage, any accession is made to the mortgage property. The mortgagee, in the absence of contract to the contrary, shall, for the purpose of security, be entitled to such accession.
This is an accession. Floors have increased. New property has come up. Who is the mortgagee?
Therefore,
who is the mortgagee here? So therefore,
I am not the mortgagee here. I am not the mortgagor. The mortgagee is bank.
So therefore, the bank is within its right. That is why, Mr. Mukherjee, I am going on saying to you right from the morning, these submissions are not going to help you. Please make a submission which will help you to show that yes, alternative remedy will not be a bar. These submissions are not barring alternative remedy. They are more enlightening the alternative remedy. They are making it more vibrant that you have to approach the alternative forum.
My lord,
please bypass that by making an argument which can compel the court to say that yes, this is a case which falls within any of the four exceptions.
Under Article 226, Lordship will also see that the extraordinary delay which has been committed by the
this again will show this. They have approached the High Court saying that the delay is because of the state, not because of them.
Again, not for me.
So not for them also. You are seeking an order against them.
Both are states. Both are organs of the
different
state.
Purpose. Different purpose, Mr. Mukherjee.
One, the State Bank of India is a state. Police is also a state.
We still have time. I can still direct. Go before the DRT. I can grant you leave to approach the bank again with a request. I will say that the bank will consider your request in the right earnest. That is the most that I can do. Because in view of the recent Supreme Court pronouncement,
Lordship will kindly give, me, today is Friday. Lordship will kindly consider.
As I cannot injunct, Mr. Mukherjee, I have said, please read the judgment. MG Rungta, 1952, referred by the Honorable Supreme Court in February 2026. So then why are you making this submission? I cannot bypass Supreme Court. If I had not known the judgment, I would have passed this order. But having come to
alternative remedy in these facts may not be sufficient, my lord. Why not sufficient?
That again, I would have understood if yesterday was the notice, yesterday was the date of service of notice, and today you had approached, I would have understood this. Yes, you don't have time. But you have wasted all the time. You have come at the last moment. Why? That again is a good ground for refusing injunction. No matter how good a case you have. You know Morgan Stanley, Chadha, all. There are several.
Those judgments may not be applicable here in this fact.
That is absolutely applicable here. There also he had approached at the last time. In Morgan Stanley, he had approached just the day before the sale. That was the case. Yes.
The fact remains that in this case, my lord, the 13th was the notice served. Kindly understand the predicament.
We are on 21st today.
My lord, kindly understand the predicaments of these persons. They are not the borrowers.
I can understand, but I cannot pass an order. There is a difference between the two. I could have understood if I was on that side and I would have done whatever I could do. Here I cannot do that.
Kindly
what you can do there, I cannot do here. So it is better you do what you can do there instead of making submissions and forcing me to do something which I can't.
No, Lordship will not do anything which is...
Yes, I cannot. because my hands are tied. I have to work within the framework of law. I cannot go beyond that.
In 226, Lordship has got
That is only
enormous.
for puffing air, nothing.
Lordship has got enormous jurisdiction. Hands are long enough to protect the rightful possession.
Within the framework of law, not
Of
beyond.
my possession is not wrongful. That needs protection.
We are asking the wrong question. To arrive at the right answer, we have to ask the right question. You are seeking a remedy against somebody. Now that somebody against whom you are seeking the remedy, you have to show that that somebody's action is wrong. Till such time that you show that, no matter how right you are, I cannot injunct that person.
My lord,
that is the problem.
My lord will kindly appreciate my possession is not wrongful. My dispossession will be wrongful.
It will not be wrongful at their instance. It would have been wrongful by your bank, because your bank did not conduct the right search. If I replace this by your lender, the bank from whom you have obtained loans, if that bank comes with a notice saying that no, you have not repaid the loan, I have mortgage, then in that case you can make this story. But not from them, because you are not their borrower. They have a right over the property prima facie.
My lord, I have no privity of contract with them.
That is why you cannot injunct them.
That is the reason why they cannot proceed against me. What they are trying to do?
They are proceeding in respect of the secured assets, which is unfortunately tied up with you.
Kindly understand the situation.
Mr. Mukherjee,
so long the silent
have already crossed. There are other 12 matter fixed 12 p.m. fixed.
The silent was in possession for such a long time. The borrowers and guarantors were in possession. They did not do anything.
These many things. When did the loan become bad? When they invoked SARFAESI action, it is nobody's case that the SARFAESI action is wrong at the moment. It has.
I cannot make that out because I do not have any documents. And at my behest also, I cannot make it out.
I also cannot merely on this basis injunct them from proceeding with the recovery proceedings.
So
you could have come up earlier, Mr. Mukherjee. If you had 5 days, in these facts, those 5 days were enough for you to approach at least this court also. You could have understood only then on that day that yes, I am not going to interfere. Therefore, you should have approached the DRT. I could have passed the same order on that day also. You would have had 5 days left. Why did you wait for this long? Why did you choose this tactics of waiting for 7 days?
No, there is no tactics involved, my lord. There is no tactics involved. Yesterday, I came before Lordship, sought liberty to move yesterday at 3 p.m.
The same day, you could have approached this court also, and you could have got the same order which you are going to get today, or you could have approached the DRT in the meantime. You have done
DRT
nothing.
takes 7 days, my lord. DRT kindly.
Not necessarily.
DRT, we are on caveat actually.
Very good.
So DRT
we have not caveat on whom?
On caveat. Possibly that is why this.
I have not received any notice of caveat. If they have sent the notice of caveat upon me, then they are aware of my existence. There is no notice on me. There is no notice of caveat.
Of justice. What I will say you will have right to approach the bank seeking time from the bank. The bank will consider it in right earnest. I cannot pass a mandatory order of injunction in view of the Honorable Supreme Court's judgment.
Lordship, may I only pray, Your Lordship, whatever decision is taken, Your Lordship, thereafter, it may be communicated to the police, Your Lordship.
Lordship will kindly record my submission that they are on the way to the police station and possibly the possession will start from 1 p.m.
Lordship, I have
17 also will become
they are present here, Your
Lordship. Nothing will happen.
I have accordingly instructed them to.
What is so much of hurry after 6 years?
Time the Honorable Court passes the order.
What is so much of hurry that they cannot wait for 6 days? Saturday, Sunday intervening. Poor flat owners who had nothing to do with it at before Lordship. Taking bank loan, they will be out of the property and they will still be required to pay up for their AMIs.
Ms. Lahiri?
Yes.
Please come to the second page of your SARFAESI, this thing.
Yes.
Yes.
Please see the street name and number.
32A.
Shukia Street.
Thereafter the street name.
Mohendra, MP, it has been typed as MP.
Will if there is a mistake in the typing, will the Sarsai still catch?
Should that I have to take instruction?
Because if this is what has been fed and you get this report, then by typing Mahendra, they may not get this report.
Lordship, then in that event, Lordship will kindly look into this judgment of the larger bench of the Bombay High Court, where it has been expressly stated that that chapter has been given a prospective effect to.
Paragraph 95.
Justice Datta's judgment.
Yes.
No.
Punjab National Bank.
No.
It is on the
Several were there.
Yes, says that Lordship will kindly take up. It is from paragraph 95 onwards.
This was regarding sales tax
Yes, sales
priority.
tax Lordship. And in that
Paragraph 95 onwards,
95
possibly.
onwards.
But my
the-
my humble submission would be.
Wait, Mr. Mukherjee,
Yes.
I am trying to help you out.
I am obliged.
I may not be
So
successful.
I am so obliged, my lord.
2019, Lordship has seen that the order of the learned CMM has been passed in 2019. Now, Lordship will kindly take up paragraph 95. Section 1, subsection 2 of 2016 Amending Act states that the same shall come into force on such date as the central government may, by notification in the official gazette, appoint, insofar as the date of coming into effect and operation of Chapter 4A of the SURFACI Act as inserted therein by 2016 Amending Act is concerned. Perusal of Section 2 of 2016 Amending Act would reveal that different dates were required to be appointed for different provisions of 2016 Amending Act to take effect and make it operational. On December 26, 2019, the Department of Financial Services in the Ministry of Finance, Government of India, issued a notification appointing January 24, 2020 as the date on which Section 17 to 19 of the 2016 Amending Act come into force. Section 18, which is relevant for the present purpose, was brought into force from January 24 to 2020, and thus Chapter 4A became operational with effect from that date. Surely, if the Parliament had intended that the provisions of Chapter 4A were to be made applicable from a previous date, the notification would have said so. Therefore, on the face of it, the 2016 Amending Act has not been made applicable retrospectively, but has taken effect from the date notified by the central government. There is other perspective from which the matter could be viewed. The statement of objects and reasons is contained in the bill for 2016 Amending Act introduced in Lok Sabha has been noted above. Reading thereof leads to the inference that the amendment was proposed to bring about a substantive change in law inter alia, denuding secured creditors of their rights of enforcement of securities under Chapter 3 of SURFACI Act if security interests created in their favor had not been registered with the SURSHI, and granting priority to the secured creditors over all other dues and taxes after registration with SURSHI, except in cases where proceedings...
Yes, but after 2020 also, for the purpose of continuing with the SURFACI proceedings which you have invoked, you have to show that you have a valid SURSHI.
Lordship.
That you'll have to show.
Lordship, most respectfully, today what I'm seeking is enforcement of an order which is already passed in 2019. It is not a fresh enforcement measure.
Yes, right. But that order will be implemented if you have a valid SURSHI registration today.
Yes. Lordship.
Because that will be a step in furtherance of the Section 13(4) proceedings.
Lordship.
So today you have to show that you have a valid SURSHI on the property.
Lordship, prima facie, I have shown that there is a SURSHI registration. Second, the order I am seeking today, I'm just simply seeking an implementation of an order.
Right.
It is
The order will be implemented only if the order is implementable. The order will become implementable only if you have the authority to invoke SURFACI. You will have the authority to invoke SURFACI post 2020 if SURSHI registration is proper. So again, it boils down to the point as to whether SURSHI registration is proper or not. Now here, in this case, then whether SURSHI registration is proper or not is a question which is to be considered. Now, if it is Mahendra Shrimani or MP Hendra Simani, whatever has been written here, if typing both would have led to this, then in that case, you have a case. But typing both would have not led to this, then you may not have a case. So what is your instruction on this?
Lordship, that I will possibly I cannot say because I'm seeing that it is typed as MP.
Take instructions on that, then
MP.
immediately ask them. Ask them immediately.
But possibly Lordship will consider that there is a today what I'm seeking is not
But Miss Lahiri, with this I am also weighing their rights, that they have a right prima facie to possess till such time that they are dispossessed in accordance with law. This disposition will be in accordance with law only if your order 14, your section 14 order is implementable. Your section 14 order will be implementable prima facie if you can show that yes, there is a valid Sarsai registration. This validity of the Sarsai registration now encircles on the property concerned. You have to then answer this. If you can answer this, I'll send them to DRT right now. Otherwise, I'll have to think of something. You please tell me that this MP Hendra and Mahendra come to the same conclusion.
take instruction in that event. Let me take instruction.
Ask them not to
because
do
all
it at
the-
one then.
Lordship, all the particulars are
I understand whether that is
at all
because
it
it can
seems
be
to be a very typographical error.
maybe
At all.
if all of them are fed or some of them is not fed, then also you come to the same conclusion. What is it? Then in that case, I can take a view, prima facie at least.
Lordship will also
Since they are so adamant that they have to do it now, despite the court's request, let them answer this.
Lordship. And
Let them answer this.
Lordship,
Come back at 1.
may I
Ask them to hold till 1 at least.
Lordship, with regard to the police assistance, your Lordship,
Please don't take till the court is hearing the matter.
Lordship, I've indicated, Lordship, we cannot take any action, your Lordship. Only difficulty would be that if it is thereafter asked to continue the process, thereafter it will be late in the evening hours. If
Whatever
it may
it
be
is,
stalled for
whatever it
today.
Maybe it is called for today. I cannot just throw it out without taking a decision on
Lordship.
I have to be satisfied. My conscience also needs to be satisfied that yes, it has caught my notice. I have put a question.
Lordship, we are teachers of instruction. Lordship, I have tried to.
I understand. Let them answer this,
Yes,
that
I will-
how can Mahendra Simani and MP Hendra Simani be the same property?
Let me come back with the instruction.
That's it. But on the last occasion, Miller, I've given the list of dates, Miller. Chief had taken note of that, Miller.
Even
the dates, Miller. Then
yes. I have those dates.
Yes.
Summons on 29 September, court reopened on 28th October, 7172 filed on 28th October, application allowed on 28th February, amount deposited on 20th March. These are the dates.
Yes, that is all. But I was also placing the impugned order. Lordship was pleased to consider that, but I had placed it till page number 12. But the submissions made, the decisions cited and everything. Judge Sahib leakages here ki kore. My lord will kindly take up the ordering portion, my lord, where the observations are. That is page 12 of the impugned order.
Page 12 of the order. Very well. Page 12.
But all judgments that could have been considered, all have been considered by the learned trial court. But page 12, my lord, I would place it, my lord, from the middle. You can take it. The defendant admittedly received the summons of the suit on 29/9/2022. In the background, the above factual position and in view of the settled position of law discussed in detail here and above, the defendant was mandatorily required under the provisions of Section 7 of the WBPT Act 1997 to deposit the amount admitted by her to be due from her on the account of arrears of rent, along with an application for determination of the rent payable within 1 month. 1 month of 29/9/2022 within 29/10/2022. Needless to mention in this regard, since this court had reopened on 28/10/2022 after Puja holidays, and also since this court was open on 29/10/2022, the fact that this court remained closed from 1/10/2022 to 27/10/2022 has no relevance in the present case. As noted earlier, the defendant entered appearance in the suit on 28/10/2022 and filed an application under 7(1) of the WBPT Act on that day. However, as noted earlier, it has been specifically held by the Honorable High Court in West Bengal Handloom Weavers Cooperative Society Limited that Section 7(1) of the WBPT Act does not contemplate filing of any application. Such being settled position of law, there was no legal stipulation for the defendant to file application under 7(1) in order to make the deposit or make payment towards admitted arrears of rent within 1 month of service of summons on her on 29/9/2022, and accordingly the pendency of the said application under 7(1) cannot come in aid to the defendant in this case. But here is the observation that during pendency of the 7(1), I could have made the deposit. Well, now kindly see. Moreover, at no stage the defendant brought it to the notice of the court that though she intended to deposit the admitted arrears of rent within 1 month of service of summons on her, but the office of this court refused to accept the same. As such, the plea taken by the defendant in this regard also has no base to stand on. The defendant admittedly made the deposits both towards arrears of rent as well as current month's rent for February 2023 only on 23/2023. If one goes by the argument of the learned advocate for the defendant that his client had 1 month time to make deposit from the date of disposal of the application under Section 7(1) on 27/2/2023, even then, the deposit made by the defendant towards the current month's rent for February 2023 was beyond time, as she ought to have deposited the same by 15/3/2023 in terms of the provision of Clause C of Section 7(1). As such, it is apparent that there is clear contravention of the mandatory provisions of law as contained in 7(1) of the WBPT Act in respect of such and such. Thus, this court has no hesitation to hold that the deposits made by the defendant on 23/2023 towards arrears of rent and the current month's rent for February 2023 are not valid deposits in the eye of law, since such deposits were made beyond mandatory time limits specified under the provisions of 7(1). As noted earlier, the objection raised by the defendant in the instant application under 7(2) regarding landlord-tenant relationship between the plaintiff numbers 4 and 6 and the defendant has lost its force at present by transposition of the said plaintiffs as pro forma defendants in this suit, and the defendant admits the present 3 plaintiffs of this suit as our landlords in respect of the suit premises, and accordingly no further order needs to be passed in this regard. With the above observations, the instant application 7(2) stands disposed of. Defense against delivery of position struck. 3-4 aspects have been considered. Number 1, 7(1).
I still had 1 day.
I still had?
Since you had 1 day.
But I really had, brother. I really had, because there was no lapse of time. On the penultimate day when the court is closing, I received the summons. On the reopening date, I filed the application. court.
And you had one more day after that to move it.
Yes, I had one more day. Matlab, thereafter, the court did not pass orders. The 7-1 remained pending, 7-2 also remained pending. Matlab, now thereafter, the learned court below is equating this with a situation which had occurred in that judgment of West Bengal Handloom Weavers Cooperative Society. Matlab,
What
this
is
has-
that judgment?
Yes, ওটা এনেছিস?
ওই judgment এর মধ্যে differentiation যেটা করে
Matlab, the differentiation has been made by Justice Hiranmoy Bhattacharya in a subsequent judgment.
This judgment also passed by Justice Hiranmoy Bhattacharya.
But that was also passed by Justice Bhattacharya, which has been differentiated by Justice Bhattacharya in a subsequent judgment. We have brought that.
Very same building, same dates are also.
Malad, it is the same building, it is the same landlord, but different tenants.
Even
Malad, the
dates are same.
landlord is upon tricking the tenants in order to get an order of eviction on the point of default. So this is happening one after the other. But in one matter, Justice Bhattacharya relieved the defendant. That I can show, Malad. This is the judgment reported.
Even the dates are also so similar.
2025 SCC online Calcutta.
Ashavan sir.
Ashavan.
The summon date are also same.
2025.
Malan, the date of summons, date of applications are also same with this.
2025 SCC online Calcutta.
3313. Malad, this Malad kindly peruse this Malad meticulously because these dates are very relevant. It is absolutely identical to our matter. The dates are also identical because on the same dates things happened. But as per my submission, para 7 is relevant and thereafter, Malad, from paragraph numbers 11 onwards. If your lordship may permit, I can read also.
Para 13 is.
Yes.
Is what is.
Is the distinction. Yes. But that the observation of the learned court below that you ought to have been vigilant and moved the court every day before the court that why my application is not being allowed, kindly permit me to deposit. Malad, perhaps nobody would controvert the situation. City civil court, small causes court, I do not know about the Alipur courts and all. Nobody can deposit any amounts without the leave of the court, without an order of the court. The record has to go and only then the challans are issued.
Yes.
Malad, here, Malad, the last portion of the observations, Malad, this order was set aside, wherein the defense was struck off.
7-2 was directed to be considered.
Lordship?
7-2 was directed to be considered.
But here the 7-2, in the 7-2, Malad, the court finds that 7-1 deposit is not in order. Invoke 7-3.
That is the natural consequence. If 7-1 is not in order, then in that case, I am not speaking about this case because we are yet to arrive at a decision here. But in a case where there is non-compliance with 7-1, 7-3 automatically will follow.
It is automatic, Malad, but
7-1, 7-2, either of them.
But Justice Bhattacharya, while considering this revisional application, made one observation which is very relevant. Malad, that observation is para number 12. But the 7-1 order that was passed by the learned court below was never challenged by the plaintiff. Malad, this is there. If that is not challenged, Malad, then that order stands.
Oh yes, that is there. But then there is a different side to it. If the court on the date when the court passed the order did not have jurisdiction to pass it, then in that case, whether that has been challenged or not will become irrelevant. Why the challenge is important? Challenging is important only so that it does not bind you as res judicata. Now there are judgments, several to this effect, that if it is an order without jurisdiction, then the principle of res judicata will not apply. So therefore, if it is held that the court did not have jurisdiction to pass the order which it did, then in that case, non-challenging will not stand in the way.
Then in that case, my lord, the court has to come to a finding. My lord, when the date of passing of an order of a 7-1, my lord, that goes off. My lord, whatever orders are passed in an eviction proceedings.
No, with respect to 7-1.
But
Yes, of
7-1, that only.
The eviction
a
proceeding
party-
will not be without
but a
jurisdiction.
party-
The court will lose jurisdiction to pass an order in respect of 7-1 after a particular time.
I understand, my lord. Absolutely, my lord. But the situation in that event,
It's
becomes,
like bar of limitations.
but it
You file a
becomes-
suit after 4 years after
but it
accrual of
becomes
cause of
more
action.
grave.
You have nothing to show that it is within the period of 3 years if the limitation of 3 years
But it
applies.
becomes more grave because the court takes in the responsibility of an application to dispose of an application and withholds disposal of such application, which were followed by series of dates wherein the plaintiff asked for time to file objections to the application and whatever other
That
events.
is in the facts of this
Yes.
case. I was
Yes, but in general also, and whatever other things occur in courts under whatever circumstances. There are
there also,
courts-
Mr. Banerjee, there will be a differentiating factor. If the date on which the plaintiff seeks for adjournment is a date beyond the period of limitation, then by the time he seeks for an adjournment, the court had lost jurisdiction.
But I would cite on judgment on that point, my lord, in order to establish before your lordship, my lord. But these are my points in respect of this judgment. Now, my lord, regarding withholding of an order or late passing of an order, my Justice Act of the Court, Justice Horish Tandon, my lord, this is 2000 as a CHN tiny, 2018 Volume 3 CHN 749. Madam, I too kindly tell.
Yes.
Lordship will kindly consider but para 2 onwards, 2, 3, 4, 5, 6 and 7. But this entire judgment. Basically. But the facts would show. But if the only ordering portion Lordship would kindly consider.
Act of court. It's all on act of court.
Act of court.
Actus curiae. Actus curiae.
Actus curiae. Neminem gravebit.
But the observation court ought to have been generous. Para 10. Malat para 8. Malat. Litigant should not be allowed to suffer for the laches on the part of the court. Para 8, para 10. এবারে কোনটা দেবো বল? But the previous judgment that we have cited, my lord, that is the same landlord, the defendant is different, and the date of service of summons and everything, those are identical. Those are identical, in which Justice Bhattacharya had relieved the defendant. এটা বলেছি পরটা
Justice Sanjeev Banerjee, without order jama nahi.
My lord will kindly consider a judgment of the division bench of Justice Sanjeev Banerjee. Oh, it is single. I'm sorry. Smart Enterprise versus Freedom Trust. Lordship will kindly consider para 6. But without the order of the court, but deposits are not.
Yes, this has been considered by the trial court also.
Para 6 is relevant.
Last Supreme Court point. Point
Yes.
But last of all, but this is abundant precaution.
This is
for abundant precaution. No, this ought not to have been given, but still, my lord, we are giving a Supreme Court judgment reported. This is Mary Pushpam versus Telvi Kuruswamy. It Judge Sahab's copy. Lordship will kindly consider para 4. But a point decided by another coordinate bench. But if Lordship differs from that,
larger bench, that is settled.
But perhaps this won't be required. আর কি বলার আছে? But that is all.
Yes, Mr. Bhattacharya.
My lord, certain facts are, my lord, admitted.
May I take your lordship?
My lord, date of issuance of summons is 29 September 2022. They entered appearance on 28th October 2022. Application under 7172 filed.
And they received summons on 29th only, or later or earlier? Issuance is 29, so they must have received later than.
Received.
As a date of receipt.
Received. And my lord, application was filed on 28th October 2022. They say that's 2 points are taken. One, court was closed due to puja vacation. And secondly, my lord, court did not pass an order for passing of the challan. Now, my lord, let us read, my lord, section 7 once.
Yes.
Kindly see. 1. On a suit being instituted by the landlord for eviction on the grounds as referred to in section 6, the tenant shall, subject to the provision of subsection 2 of this section, pay to the landlord, kindly marks this, or deposit it with the civil judge all arrears of rent, kindly marks this, all arrears of rent calculated at the rate at which it shall it was last paid and up to the end of the month previous to that in which the payment is made, together with interest at the rate 10% per annum. When they thought that the court was delaying the matter, my learned friend has, my lord, taken the judgment, shown your lordship the actus curiae concept. My lord, there are two modes of payment. My lord, let my learned friend show anything that they have attempted to tender it to the landlord, because under the statute that is also a valid deposit. What prevented them? Under the statute, they have
two modes are there.
Two modes are there. You can opt any one of them. When you are sure, you are that I have to file the application within time and I have to deposit, then you should not have waited for the court to pass an order. In view of the stringent provision and the stringent judgments of Chamaria is there, 7 day is there, HON'BLE is there. You should not have waited for that. Now, Miller kindly takes up page 35 of the civil revisional application. Yes, Miller starts from 34 and then 35. Yes. 34, my lord, is the order dated 28 February 2023. Kindly see. Today is fixed for filing written statement and written objection. Both parties are present by filing respective hajiras. Defendant moves the application which has been filed under section 7(1) of the West Bengal Premises Tenancy Act. Copy has already been served. Heard the learned advocate of the defendant with regard to the petition. The petition under section 7(1) of the West Bengal Premises Tenancy Act filed by the defendant is hereby considered and allowed at the risk of the defendant. Therefore, court allowed it at the risk of the defendant. They had taken a chance. Court said very well. You have filed an application, you deposit it at your own risk, because court at that time was also sure that whether he can at all allow it or not. But since an application was filed, you deposit it at your own risk. It was the defendant, my lord, who, my lord, there is nothing on record which shows, my lord, the defendant had at all attempted to move the application. They say the court passed the order. My lord, let my learned friend show, my lord, a single document by way of put up, my lord, they have brought it to the notice of the learned court. Because you are not passing the order, my defense will be struck off if I can't deposit. Let my learned friend show one put up petition. Lord, I filed a civil divisional application that is kept pending, Lord, that is appearing in the monthly list. In the meantime, Lord, the suit itself is declared, it's decreed. But can I come and, Lord, question the court, Lord, for your fault, you did not take up the matter where the suit is decreed? Can I say so? The matter is running in the monthly list. You have to say so. That is mentioning for upgradation. That is mentioning for upgradation, not leveling allegation. Right. The Millard, then Millard kindly comes to Millard page 35. Page 35. 35. Yes. Now Millard, they deposit it, Millard, being pursuant to the order. This is Millard, they say. Now Millard, kindly see Millard, what does they say, Millard? The fourth column, Millard, on the right hand side. Rent for the month of August 2021 to March 2022 and September 2022 and October 2022. Millard, this they say we were defaulter for this part. Millard, kindly see, Millard, when it was passed, Millard, 20th March 2023. At the bottom, kindly see, Millard, the seal and signature is 20th March. Millard, this is impermissible under the Act. I kindly now, Millard, 7.1b. Kindly sees, Millard, 7.1b. This is impermissible under the Act. Now, I will also demonstrate, Millard, now Justice Banerjee's judgment, smart, Millard, then Millard Dilip Das, perhaps my learned friend has relied upon. Millard, these have all become, Millard, bad judgments after, Millard, 7th day. Yes. Kindly see, Millard, B, 7.1.1a I have placed. Now, Millard, see B. Such payment or deposit, such payment qualifies the payment in 7.1a. Or deposit shall be made within 1 month from the date of service of the summons of or the tenant, and when or where he appears in the suit without summons being served upon him within 1 month from the date of his appearance. The tenant shall thereafter, that is 7.1c. B is the rent has to be, this Millard payment has to be, Millard, accompanied by along with the Millard 7.1 application. On that day when 7.1 application was filed, you should have filled up the challan and Millard brought it to the notice of the court that I am filing it along with this application under 7.1. This is, Millard, I shall also be relying upon Justice Sarkar's judgment, Millard, which says this amount is, Millard, it has to accompany with the period of default, the default part, it has to accompany with the application itself. Pre-deposit is a mandatory requirement under the statute.
But they say in city court they won't allow.
Millard, judgments are there, Millard. They should have, Millard. Then Millard, the other part of my argument is there.
Pay to the landlord.
Pay to the landlord. Pay to the landlord. Why didn't you pay to the landlord?
There is no averment in the petition.
No.
They tried and they didn't.
LDC, Millard, 7.1. Page 23.
Page 23.
Yes.
Yes.
Government refused to accept, that is pre-suit.
Page
Para 20, page 24, man.
Yes.
Page 20?
Page 24, man. Para 4.
Para 4. Yes, that is pre-suit default. That is before filing of the suit.
Para 4.
I refuse to, Millard, accept they are paying it before the rent controller. That is the, Millard, point taken in every suit.
Because it is only then that you will be able to file.
Exactly. Thereafter, the rent controller, that's when suit is filed before court.
After suit, no tender.
No tender.
Well, after suit, why the rent? Well, after suit, why the rent was not tendered? I have stated in my application because, my lord, the landlord of the building is not residing in the property. Even where he is residing, there is. I have stated that we have tendered before filing of the suit.
After suit, you have.
After suit, after suit, my lord, I totally agree with you, my lord. After suit, my lord, there is two provision, or either pay to the landlord or deposit with the civil judge.
Feel that there are two provisions, but if you feel that the second provision is going to delay the matter and take you out of the purview of 7.1, then should you not also try under 7.1?
The problem is only that, my lord, there is no access of the landlord. Even my lord, the landlord is not there. But that is not in the pleading. That is a fact. My lord, that is not in the pleading.
Because my next judgment which I will be citing is Manup Chaudhuri, my lord had decided it in court number 6. I had the occasion to appear. Now, my lord, kindly see, my lord,
high judgments are usually wrong judgments.
no, my
not
lord,
citable.
this is in my favor, my lord. Okay, page 13 of the impugned judgment.
Page 13, one
Yes,
three.
last page. The second paragraph. Moreover, at no stage the defendant brought it to the notice of the court that although she intended to deposit the admitted arrears within 1 month from the date of service of the summons, or he or her, but the office of this court refused to accept the same. And as such, the plea taken by the defendant in this regard has no base at all. Milord, court has, Milord, nothing.
Page 13, which paragraph?
Second paragraph, Milord. Moreover.
Yes.
Now, Milord, this is Milord 7.1 part. Now, Milord, kindly see, Milord, they are also, Milord, defaulter in terms of 7.1c. But there, every provision they have defaulted. Kindly see, Milord, what does 7.1c say? The tenant shall thereafter continue 15th day of each succeeding month. Now, Milord, kindly see, Milord, page 100 and 106 of the civil revisional application. Page 100 and 106.
106, yes.
Milord, kindly see, Milord, the particulars of the receipt, Milord. Kindly see, rent for the month of September and October 2023. September and October can't be, Milord, in one month. He is depositing it on 11th October.
Page 106 is for
100.
Yes, September and October.
Yes. Clubbing of rent is not possible.
Unless it is advance.
Unless it is advance. Kindly see, it cannot be advance. And pay at the seal, kindly see.
September is before the since they are filing in October, on October 10 they are filing, so September is in default.
2023. This is 2023. That is 2022.
No, but they say rent for September, October 2023 only.
Yes.
Yes.
Arrears are in 2021. Two.
This is not current.
This is current. 7.1c. Where is the compliance of 7.1c? 15th day of each succeeding month. Month by month and 15th day of each succeeding month. Kindly see, Milord, 7.1c. Once. Milord, kindly see,
yes,
Milord.
but for September, the succeeding month will be October, within 15th of October. So this is 10th October.
Then, Milord, October when he is...
October is filed in October only. So there is no default that way.
Within November.
October is advance.
October has to be filed within November 15.
But he has filed it in October itself.
But clubbing of rent is not permissible.
No, if it is advance, there is no default. No.
Brought
it won't be default.
The special bench judgment I have brought.
Yes.
Then, Milord, kindly see, very well. Kindly see, Milord, 106.
106.
Kindly see, Milord, November and December cannot be paid on 20th March.
Yes.
Even January and February cannot be paid in, Milord.
Till January there is default. February may not be. February also,
Milord, these, Milord, they can't say court did not pass order.
All of them are in default.
All are in default 7.1c.
November to February, all of them are default.
And it was not within 15th on every month. Therefore, there is, Milord, 7.1c, Milord, is applicable.
And 6 is right.
Now, it was Supreme Court, 79 Supreme Court. Oh, data. 65 data.
Yes.
Yes. Milord, this is AIR 65 Supreme Court 1909. 1909. Now, my lord, kindly see, my lord, this was also a case, if your lordship would kindly see paragraph 3 and 4, my lord, of the West Bengal Premises Tenancy Act 1956, my lord, lordship will find, my lord, 17.3, 17.2, my lord, these are there. Now, my lord, kindly comes to, my lord, 16, para 16. My lord, it is also relevant to remember that in the matter of payment of the rent in court, section 17(1) has provided that the amount is to be paid in future shall be paid within 15th of each succeeding month, and that means the date for the payment of the amount has been statutorily fixed, which is distinct from the requirement of section 4. Section 4(2) provides for payment of rent within the time fixed by the contract, but section 17(1) requires the payment to be made by the 15th of each succeeding month, whatever may be the contract.
That's right.
Next line. If according to the contract, the rent was payable quarterly or sixth monthly or eventually section 17(1) annually, section 17(1) supersedes that part of the contract and requires the rent to be paid, kindly see, month by month by 15th of each succeeding month. Therefore, clubbing of rent, that is
you will have to read it in the sense of the preceding lines.
Yes,
also.
my lord. Yes, my lord.
Because if 6 monthly rent is contractually payable, then in that case, barring the 6th month, the first month will be in default going by this, because it is not within 15th of the next succeeding month. The first month's rent is coming after 5 months. Therefore, that is in default. You have to read it in that context. It will not mean that if the rent of February and January both are being paid by 10th of February, the rent of February will be bad.
No, my lord, then, my lord, this line, the last section 17(1) supersedes. It supersedes the contractual obligation, my lord. Kindly
supersedes the contractual obligation of paying 6 monthly rent, in the sense that the earlier rents, the default will not be cured by this.
In any way.
Because this judgment has to be read in the line of default only. So your 106 is right.
Apparent.
100
very good.
Is not.
Ever 72 paragraph 2 কোথাও বলেনি advance এর কথা।
Kindly comes to, my lord, page 24.
Page 24 of the
revisional application, my lord.
Yes.
Yeah, 3.
Kindly see paragraph 3.
According to the English
Paragraph 3.
কোথাও advance এর কথা বলেনি।
My lord, kindly see, my lord, that without prejudice to the petitioner's right and contention in the suit and the statements and made in the written statement, the defendant states that your petitioner has been holding the tenancy in respect of 2 residential rooms, etc., for 5th floor at premises number such and such at a monthly rental of 1655 as Kolkata Municipal Corporation as monthly charges and amenities at the rate of 10% and payable according to English calendar month under the plaintiff number 1, 2, and 3 as landlords. হ্যাঁ, এখানে তুমি কি বলতে চাইছো?
না, কোথাও অ্যাডভান্স বলছিল না, অ্যাডভান্সের কথা কোথাও বলা।
Yes, my lord, my lord, the observation, my lord, which fell from your lordship with regard to, my lord, the 65 Supreme Court, if, my lord, there is a contract, my lord, for advance payment in lump sum, my lord, that is neither the case of the plaintiff nor the case of the defendant, my lord.
Even if it was a contract, the contract will not override the statute. If the statute contemplates payment of rent by by the 15th of the succeeding month, it has to come. If it has crossed the 15th line, then it is a default. It is a default in payment.
The next judgment which I shall be relying on, pre-deposit. No, pre-deposit. Justice Sarkar বোধ হয় না, pre-deposit 7(1) এই দুটোর মধ্যে একটা দেখো, সুমিত সিং বা অসিত দাস, তাই তো?
Yes.
এইটা হচ্ছে কোন প্যারাগ্রাফটা বলো?
14, 22, 22.
My lord, kindly comes to, my lord, page para 14. তাই তো? 14, my lord, 7 day was cited. sorry, এটা হচ্ছে সুমিত সিং, CO 1969 of 2025. আমার হয়ে গেলে আমি দিচ্ছি। Kindly comes to para 32. Kindly see in this context, we see that the intention of the legislature as discussed and relying upon two cases of three-judge bench of this court, we intend to explain section 7(1) of the West Bengal Premises Tenancy Act when a tenant can get benefit of the protection against eviction. The opening word of section 7(1).
This is a quote from 7 day.
7 day, yes.
This is a quote from 7.
This is a quote from 7 day, and Milord, ultimately, Milord, kindly see, Milord, 33. No, 33 কোথায়? 33.
This is all 7
Also quoted, Milord, for Lordship has, Milord, stated, Milord, ultimately defense has been struck off for non-compliance of 7A, B, and C all. Kindly see 33, Milord, 7A, B, C all.
That is 7th day mandate.
Mandate, Milord, my Lord has ultimately, Milord, upheld, Milord, 7.
Supreme Court. So just quoting.
Exactly. Only Milord, paragraph 23, Milord, my Lord's liberty was Modula India versus Kamakha Singh Deo, Milord, paragraph 23, Milord, they can at best cross-examine. আচ্ছা, এবার ওই রিডিপোজিট, আরে অতীশ CO 2023, volume 4, CHN 653.
Page
2023, volume 4, CHN 653. ওই একদম ওই জায়গাটা দেখো, প্রি ডিপোজিট ইজ ম্যান্ডেটরি।
Paragraph?
Fine. Kindly see, Milord, para 3. What was the issue? The petitioner filed an application under 7(1) of the Act, under the West Bengal Premises Tenancy Act, contending inter alia they had received summons on September 2022 and permission to be given to deposit the monthly rent of rupees 1,700 per month from the month of September 2022. The petitioners filed an application under section 7(2) of the Act. They contended that summons were served upon on September 9, 2022, and an application under 7(1) of the Act has been filed claiming to be the monthly tenants at a monthly rental of rupees 1,700 per month in respect of the shop room as mentioned in the schedule of the plaintiff. The plaintiff's opposite party number 1.
How long will you take?
Another 2 judgments.
Because Mr. Banerjee will need to reply again. They will not be able to conclude today, that means. We can have it next week then.
কবে তো ডেট আছে?
Lordship will kindly, I have asked my clerk to get a printout. I still ask that asset-based search report, whether that is showing or not. Because the asset ID based is showing. They have shared that with me right now.
Asset ID, I am not privy to.
What about the address?
Yes, that is that A has been mistyped as P. That is there, Lordship. So I have asked them to share the asset-based search report, whether that is showing or not. This is an asset ID-based search report.
What are they saying? They will go today or?
Law
My
officer,
lord,
I'll
my
talk
lord.
to law officer could not come. He is under some medical difficulty. That is why I'm having so much of difficulty in coordinating.
I understand. I don't want to
My
put
lord,
anybody in
the asset
trouble, but-
based.
In any event, Lordship, I'm told that there is a judgment also of the Honorable Supreme Court that mere typographical error will not nullify the certiorari registration.
That won't, but it is not a question of nullification. It is a question of them not being able to search.
But Lordship will also kindly look into the locus, because today they have imperfect title. Their title is itself a nullity. Whether in these circumstances, Lordship can give.
Yes, in view of the provision of Transfer of Property Act, where the subsequent transfers will be subject to the earlier transfer.
Yes. Lordship, their title I have shown prima facie, they do not have title.
Mr. Mukherjee, don't
So how
waste
can
time.
they come in the
Go
way?
before the DRT. I'm granting you leave and request the bank for some time, if you can do.
Lordship may
Well,
pass necessary directions.
asset-based
Police
search
assistance.
report.
Lordship may pass necessary directions upon the
I'm
police.
not passing any direction. I'll just
In any event,
send him to DRT.
Lordship, because we are waiting at the premises.
So you, if I don't restrain, and if you get instructions from the bank, you will have to act according to the bank, because it is not the bank's petition nor the state's petition. I will only say that the reliefs which he has prayed for here cannot be granted by this court. They will be granted by the DRT if the DRT finds a
Lordship,
case.
in that even the order remains in effect, your Lordship.
Remains
And
in
then if the bank is there, then we will have to carry on with the.
Madam, the borrower, sorry, the petitioner will have to sit with the bank, and if he can request the bank and come to a conclusion, all very good. You will act according to the instructions of the bank, whatever the bank says.
Lordship, I'm only humbly praying, since the police authority
Please Google it, you will find it. This is Mangal Rajendra Kamthe versus Tahsildar Purandar and others. And the words are, I am reading it aloud. We trust that the High Courts will duly take notice of these binding precedents and hope that no case of a similar nature arises in future for our consideration.
possibly 2026 SCC online SC 297.
I am aware of that.
That is why I am saying, because it's impossible. I have to work within the framework. There is somebody over me. I'm not Supreme Court. I don't have that 141 authority.
Lordships are supreme in their own domain.
No, no. You are saying this because you are that side. I would have also said that. I can't do it.
That are notice ready. Well, there are one or two typographical corrections which I'll just make and hand it up to your lordship within the course of the day. Well, I think we have covered most of the submissions. I'll just quickly just summarize it, and I think I can end with that. Well, the application that was made before the court was under section 151. That application was made after the preliminary decree was passed. The preliminary decree was challenged before the High Court. The High Court modified the preliminary decree only by including two flats instead of one. That is the sum and substance of the matter. Now, so far as that is concerned, after the preliminary decree is passed and modified by the High Court, the plaintiffs in the suit, who are the opposite parties now before your lordship, they go back to the first court and make an application seeking the appointment of a commissioner of partition to give effect to the modified preliminary decree. At that juncture, the petitioners before your lordship make an application under 151 saying that first there should be an adjudication of their subrogation rights. It is that application that was dismissed against which we have come up in division before your lordship. Now, the only two grounds on which the application was dismissed are number one, that you have already approached the High Court, in a separate proceeding for adjudication of the same question. And number two was when you came up in appeal before the High Court from the order that was from the challenge to the preliminary decree, this question was not raised. If today we are confined to that, the answer becomes very simple because simpliciter, the other suit, which is 377, which you have now brought on record before your lordship, is for a suit to share in the common family expenses following a family settlement and arrangement. That has nothing to do with the mortgage or the subrogation rights. That is already on record. We have indicated the page numbers. I'll just cross check it and hand it up. Secondly, the High Court in its appeal against the preliminary decree was not in any manner concerned with the question of mortgage or subrogation. The only question was whether the decree should include two flats instead of one. Because the partible asset was one flat or two flats. That was the only issue. So there was no question of going into that. Secondly, so far as this issue is concerned, the next question which was raised by Mr. Chaudhary in the course of his arguments was that this was never a part and parcel of the pleadings in the original suit. And so therefore this could not be a question of adjudication before the first court. Now, so far as that is concerned, we had referred to an additional written statement that had been filed in the suit, where the question of release of mortgage was very clearly made up. And so far as that question is concerned, that issue was raised before the first court at the time of hearing for the purpose of granting the preliminary decree. The first court at that point of time goes into the question and says that, look, at this juncture, I will not go into these questions. At this juncture, I am only concerned with the question of what is the share of the parties in the particular assets. And that is all. And these questions will be left for adjudication at the time of final. Clearly mentioned. Speak. Now, so far as that question is concerned, so therefore this is a part of the pleading. Now, the second question was whether, we can at all, assert a right of subrogation, because the question was that you have not, in fact, redeemed the property in its entirety. And section 92 was referred to suggest that unless the redemption is complete, you cannot avail of your subrogation rights. Now, so far as that is concerned, we showed to your lordship the written objection that was filed to the section 151 application, and also we brought on record by way of a supplementary affidavit with your lordship's leave, two gift deeds. They clearly acknowledge the fact that the entire bank's dues had been paid. However, the bank had not proceeded to release the title documents. Bank has, however, not taken any steps to foreclose the mortgage or to enforce the mortgage at all. So, here, so far as the parties are concerned, according to them, the mortgage has been redeemed in its entirety. And the right is the right in equity, which has been recognized by the Supreme Court. We don't have to do anything beyond that, because I can claim my lord, contribution, my lord, to what I have paid on behalf of my lord, my co-mortgages. My lord, I had on the last occasion given your lordship the example of my lord, the surety. And my lord, I had also, my lord, showed to your lordship exactly how the Supreme Court has also proceeded on the same line. My lord, the idea being that if I have today paid a due, which was payable by you, in that case, I have a right to contribution from you to that extent. Now, my lord, so far as that is question, so my lord, the next question that my lord, Mr. Chaudhary had raised, that you have not completed the subrogation. Now, my lord, the question of my lord, estoppel comes in here because my lord, you have yourself accepted that the bank's dues in entirety is paid. And my lord, in the gift deed, it says, although the bank dues is paid in its entirety, the bank has not released the document. Wrongfully not released the document, that is the assertion. Now, my lord, the next my lord, point that was raised.
But then, Mr. Saha, for you to claim subrogation or the say replenishment of the contribution that you have made for the purpose of redeeming the property, you have to show that you have done it. The
that is,
if the gift deed says that it has been redeemed and stops at that, does it mean that has been redeemed by you only?
My lord, no, my lord, that is accepted. Redeemed by me is accepted. Now, my lord, when I go before the learned first court and I say that I have redeemed it, but it is open for my learned friend to say that no, you have not redeemed it. I have also paid in the redemption. But my lord, that is my lord, a question which would have to be gone into.
We have delayed evidence.
Unfortunately, my lord, the first court does not go into those questions at all. And my lord, when we are in revision, what are we doing?
No, but Mr. Sahab, relying on the gift deed, your case is that the gift deed says that you have redeemed.
Yes, defend number 3. 3 documents. One is their own written objection to the 151 application. And there are 2 gift deeds. Now, my lord, they say clearly the defendant number 2, my lord, which is the my lord, applicant before your lordship, my lord, has redeemed it. Now, my lord, the question is, my lord, it is always open for a party to say that, my lord, you have not done it. In fact, my lord, the learned, my lord, first court records this clearly in the order. My lord, may I just, my lord, quickly show your lordship, my lord, what were the disputes and what is the, my lord, order of the first court in the preliminary decree. That is very important. My lord, please come to, my lord, volume 2 of the revisional application at page 149.
Volume 2, page 149.
My lord, 149. My lord, paragraph 82. My lord, what does single, my lord, first court say? Before deciding the question as set forth. I'm sorry.
Yes.
Paragraph 82.
Yes, you had pointed that.
Yes. And I just read it once again, my lord, just for your lordship's, my lord, recollection. Before deciding the question as set forth, I will like to keep it on record that for the present, I am not inclined to get involved into the question whether.
This was the preliminary decree.
Yes.
Postponing it to the
Yes.
to a
And my
later
lord
stage.
says who mortgaged it, for what purpose was it mortgaged, who redeemed the mortgage, to what extent, all these questions will be gone into. Now, that question will not be gone into by your lordship. Your lordship is only exercising a supervisory jurisdiction. And my lord, to see what, my lord, whether the learned, my lord, first court has abdicated a duty which was for it to function, to perform. And my lord, all that we are saying is, my lord, he should have gone into these questions. And my lord, this was an issue raised and issue left open to be decided at the final decree stage. Now, my lord, the second question that your lordship asked. Well, all these documents on which we are relying have been all exhibited in the suit.
It's records in it.
And my lord, that your lordship find from page 140 of my lord volume 2, where your lordship find a record of all the exhibits. So, well, naturally, the documents are before the first court, well, to go into and decide as to, my lord, whether the property has been redeemed,
Who has redeemed?
whether it is entirely redeemed or not, who has redeemed it, who is entitled to a
What is the
contribution,
money I have
and
paid?
how it is to, my lord, ultimately reflect on the final decree. Page 140 onwards, your lordship find all the documents are, my lord, exhibited.
My bank statements are exhibited. I have paid.
Including, my lord, my bank statements to show that, my lord, I have paid the bank. Now, just to answer my lord, your lordship's query as to my lord, whether it will be evident that so I have my lord redeemed it. Of course, this is a question to be gone into by the first court.
Yes, since
But
the
I must
first court
satisfy-
has not yet answered that, that was just to see what your case is.
No, but my lord, my lord, conscience must be first satisfied. My lord, that is my lord the most important thing. Please, my lord, have a look at the written objection filed to the 151 application. এটা কোথায় আছে written objection আলাদা করে দেওয়া হচ্ছে কোনো?
আলাদা করে।
Well, that was separately, my lord, handed up, my lord, Mr. Chaudhary.
written objection to that? এটা annexure করেছিল তো।
The previous occasion, my lord, I'm told it was given by way of
Supplementary, yes.
supplementary.
হ্যাঁ, page 203 W order আছে already.
Yes. Yesterday, I mean, the last occasion supplementary was filed.
I'm sorry, my lord, it is already there. It is at page 203.
203.
My kindly forgive. Page 203.
Oh, then it will not be written objection because written objection wasn't annexed. Page 203.
This is a written objection.
Objection to our 151. হ্যাঁ।
Well, this is, my lord, the written objection to our 151 application. And my lord, here, your lordship will see paragraph 7.
হ্যাঁ, paragraph 7 টা পুরো পড়ো। হ্যাঁ, page 2.
This is your 151 application.
Yes,
Yes.
sir. Well, if your lordship will straight away come to my lord, last 7 lines of paragraph 7. 7 or 8 lines.
Two double one.
That's right.
It is not his case that he has paid.
Well, lord, this is what he says. Last time, the repayments of bank dues. Repayment of bank dues were made using the borrower firm's resources, and if at all, the defendant number 2 has only discharged his own bank liabilities for which he alone is responsible. So, my lord, no one else has done it. Defendant number 2, my lord, I was the defendant number 2. And please have a look at, my lord, the gift deeds, just one paragraph of the gift deeds. My lord, the first gift deed, my lord, is at, all page number 2.
Gift deed এখানে লাগানো নেই।
No, এটা আমরা supplementary দিয়েছি তো একটা।
এই যে RC, page 82, paid to bank, হ্যাঁ। Page 81.
Of the supplementary?
Supplementary, yes.
Well, a supplementary affidavit that we had filed at page 81. This is a supplementary affidavit.
Page 81.
Yes, supplementary that we have filed.
At page 81, just one paragraph, paragraph P.
P and A. Q. P and Q.
Let please see paragraph P.
ওতে বলা যে সিকিউরিটি হলো দেন পেমেন্ট।
Paragraph?
Well, O and P. In fact, P itself is not good enough. Casual family for its business purposes had obtained bank finance, and for that purpose the combined flat was provided as a collateral security to the New Bank of India Limited, which subsequently merged with Punjab National Bank, and the title deeds of the entire combined flat, including the share of the donor therein, were deposited with the bank for creating mortgage by deposit of title deeds in favor of the said bank for providing loan to Subhadra Trading Company, a partnership firm of the Kejriwal family. Subsequently, the said bank transferred all its rights in such loan granted to Subhadra Trading Company, including the collateral security in favor of RCIL. Although the entire claim, well, this is very important, although the entire claim of the said bank has been paid, but RCIL wrongfully initiated recovery proceedings and issued advertisements for sale of combined flat. However, the Honorable High Court directed RCIL not to take any step for recovery, etc. And this is the same thing has been repeated in the next gift deed also.
Who is the donor donee?
And my lord, so far as the donor is concerned, this is the statement is being made by my lord, the plaintiff number 1 in the suit, my lord, while making a gift deed in favor of the plaintiff number 2 in the suit.
Ramesh too.
Similarly, my lord, your lordship sees the next gift deed, which is a 25 deed. My lord, that is at page
44.
44 or 90? 44. 44.
Same pair.
Let again paragraph P and Q.
Page?
Well, at page 44. At 52.
What is the deed?
Yes, sir, at 52.
At 52. This is between whom they can.
Well, at paragraph P talks about the creation of the mortgage. Well, a title
This
deed
only
of,
shows that entirety of it has been paid,
yes,
but it doesn't say paid by you.
No, Malad. That Malad, you will also see Malad first from the written objection, defend number 2. It says if you have paid because you've discharged
But that is if and but. And there is no surety that you have paid.
No,
If you have
Malad,
paid, it was
that
your.
Malad, to get that surety, your lordship will find Malad from my assertion in my 151 application that I have discharged it. And Malad, so far as the rebuttal to that is concerned, I am showing your lordship Malad documents to Malad answer 2 questions. Question number 1 is Malad, has it been redeemed in full? Malad, that Malad is here from the deed.
Now whether you have redeemed it.
Yes. Question number 2 is who has redeemed it? Now, Malad, that is my assertion in my application, and your lordship will find that that assertion is not denied.
And the learned trial court has not found anything on this.
No, nothing. I'll show your lordship Malad, the opposition.
It's not going. 151.
Malad, if your lordship sees, Malad, paragraph 9 of my 151 application.
Page?
Malad, this is at page 189.
Page 189 of the revision.
Of the revision. Well, at paragraph 9, on perusal of the additional written statement filed by a petitioner, it will appear that your petitioner has specifically asserted therein that the flat number 3A situated premise number such and such, well, it was mortgaged with the Punjab National Bank, now assigned to RCIL, and the other flat number 3B situated at the same premises was mortgaged with Indian Bank. It was further asserted by a petitioner that the defendant number 3 had left no stone unturned for sale of the flat numbers 3A, B situated at the said premises in the recovery proceedings pending before the Land and Debt Recovery Tribunal initiated by the banks and the financial institution. However, your petitioner and the deceased defendant number 1 had made substantial payments to the banks and the financial institutions to ensure that the said flats were not sold off in the recovery proceedings. Your petitioner had also filed evidence on affidavit and supplementary evidence or affidavit copies whereof. On perusal of the evidence on affidavit and the supplementary affidavits of affidavit, it will also appear that it was specific case of the petitioner had paid substantial amounts of preservation of suit properties and ensured that the properties were not sold. And Malad, that is Malad, how it proceeds. We have given details of Malad, all payments that were made to the banks.
Everything.
And Malad, then Malad, we say that
particulars are given. Key payment করেছে.
Malad, we have given the particulars of payments. Now, Malad, if your lordship sees the written objections, how these paragraphs have been dealt with.
11.
Malad, that your lordship find from Malad, the paragraph 7 that I showed you, lordship. Malad, that is their answer to Malad these questions. They say that if you've done it for yourself. Well, that is how they've dealt with. So, Malad, there's no denial of the fact that payments were made only by me. So, Malad, just coming back to Malad, the argument that Mr. Chaudhary had made. First, he said that Malad, so far as the question of Malad redemption is concerned, it has not been redeemed. That's his first Malad assertion. Secondly, he says Section 91, Section 92 requires Malad a redemption in its entirety. Without that redemption, it cannot be made. Well, that question is answered.
And it's not there in your pleadings, no evidence.
Yes, but that is my written statement, additional written statement. And Malad, evidence is fully disclosed. Malad, paragraph page 40 onwards, you'll also see all the documents have been exhibited to show that I have in fact discharged Malad the debt and redeemed Malad the mortgage. And Malad, the next thing is, he says that, well, if you have in fact redeemed, then you have stepped into the shoes of the mortgagee. And for that, you could have foreclosed the mortgage or filed a suit for Malad on the mortgage. You have not done so. Malad, that is not necessary because Supreme Court recognizes this is a right in equity. Malad, it becomes Malad the position of a surety. And Malad, I have a right to Malad contribution. Well, for that, my lord, I had briefly drawn your lordship's attention of the three judgments I've cited. I had, my lord, drawn your lordship's attention to, my lord, one judgment, my lord, that was 1979, Volume 4, Supreme Court Cases 429, which, my lord, in paragraph 28 clearly says that it's a right in equity. Just that one paragraph, if your lordship just permit me to place for a second. Just one paragraph I want to show you, lordship. There's elaborate discussion in all the judgments, but just to emphasize this point,
28.
Just one paragraph. Steering clear of the tangled web of conflicting and confusing decisions rendered on an interpretation of the relevant provisions of the Transfer of Property Act 1882 as they stood before the amendment of 1929, we may say at once that even where the Transfer of Property Act was not in force, a redeeming co-mortgagor discharging the entire mortgage debt, which was the joint and several liability of himself and his co-mortgagor, was in equity entitled to be subrogated to the rights of the mortgagee redeemed and to treat the non-redeeming co-mortgagor as his mortgagor to the extent of the latter's portion of the share in the hypotheca and to hold that portion or share as security for the excess payment made by him. This equitable right of the redeeming co-mortgagor stems from the doctrine that he was the principal debtor in respect of his own share only, and his liability in respect of his co-debtor's share of the mortgage debt was only that of a surety. And when the surety had discharged the entire mortgage debt, he was entitled to be subrogated to the securities held by the creditor to the extent of getting himself reimbursed out of the amount paid by him over and above his share to discharge the common mortgage. But it does not say that, my lord, you will ultimately have to go and file a suit. I don't want to do that. All that time, my lord, I am subrogated to the position of a surety. And, my lord, it is the same principle that if I have, my lord, paid off as a guarantee, if I paid off the debt of the principal borrower, then I can realize from the principal borrower. That's the right of contribution. Same. That's well, Mr. Chaudhary very well kindly points out section 69 of the Contract Act, my lord, which follows the same principle.
Yeah, I'm accepting the
Against
principle.
first, that's
You will have right to claim the money from me.
No, that's all right, my lord. Today the question
I
is,
accept
my
the
lord,
principle.
if I claim the money from you and I have a right over, my lord, the property, my lord, what happens? The charge shifts. My lord, we are talking about a mortgage. We are using the expressions mortgage or mortgage. We are saying that, my lord, today, my lord, the right to the property, because you step into the shoe of the mortgagee, notionally. And, my lord, what happens? You therefore have a charge over that property. Now, my lord, if today your charge is not satisfied and the property is dealt with, well, the question is what will happen? Well, it's the same principle. It's a very common sense application to the whole approach. Well, that is what one has to look at. My learned friend says that no, you may have ultimately stepped into the shoes of the mortgage, but that will only entitle you to file a suit to foreclose that mortgage. No. Then, my lord, the question of, my lord, my being a surety and that being a security, my lord, that vanishes. My lord, kindly, instead of, my lord, co-mortgages, my lord, consider it from the perspective of a third-party borrower whose debt I have guaranteed. So, my lord, one has to, my lord, in understanding and interpreting and applying the law, has to, my lord, also vested with some, my lord, semblance of sanity. My lord, this was, my lord, the third objection that he raised, and then, my lord, he goes back to the, my lord, question of, my lord, so far as this is concerned, he goes back to the question of, my lord, several other suits have been filed, my lord. I had shown your lordship the plain file.
And what about the abandonment of the arbitration?
No, but so far as that is concerned, my lord, the arbitration is commenced by my lord friend.
Yes, but
Now,
this question
no,
was
well,
also there.
let me answer that straight away. My lord, today, my lord, that question, my lord, first of all, my lord, is my right taken away? My lord, I have not filed the suit. My lord, the arbitration was filed by my lord friends.
But you had a counter claim there.
Of course, of course. But, my lord, kindly consider, if the claimant does not proceed, my lord, counter claimant could have proceeded. But, my lord, here it is abandoned, and, my lord, the arbitrator.
Then you have also abandoned your counter claim.
No, my lord, it's not like that. My lord, what happens here is, my lord, the arbitrator has, my lord, said I am functus officio because none of you have, my lord, renewed my jurisdiction.
Yes,
I mean,
but that applies to you as well because
But
you
then,
are a
my lord,
counterclaimant.
that will put paid to, my lord, all the claims and counterclaims before the parties. Because, my lord, what happens is there is no, my lord, no res judicata because there is no adjudication on merits.
No, but then there is waiver, sort of.
No, my lord. My lord, the question is, my lord, my lord, today one can say that I have relinquished my claim. My lord, waiver is relinquishment of a known right.
Yes. So you
Relinquishment is a, my lord,
once you file a counterclaim, you stress your right, then you abandon it. What is the effect?
no, my lord. The question
It's
is, my
like
lord,
withdrawing the suit.
today, my lord, the parties, my lord, can choose a different forum. Now, my lord,
Only if the first forum chosen by the parties has by reason of some law become defunct and this right is still reserved to you. But if you waive your right in the first forum, will the second forum still be
my
available?
lord, here, my lord, the question is, my lord, what was the, my lord, then, my lord, your lordship will have to see, my lord, what was the claim and what was the counterclaim. My lord, the claim was with regard to, my lord, the partnership business. Now, my lord, the counterclaim was made in the context of the partnership business. My lord, may I then, my lord, show your lordship, my lord, the first the counterclaim. My lord, two arguments
Yes,
here.
because that was a question raised, so I'll have to.
No, my lord, very well. My lord, I'll answer that question. Two arguments. My lord, one is, my lord, when we talk about abandonment, my lord, we talk about giving up a right in perpetuity. Now, my lord, so far as giving up a right is concerned, in law, I give up a right if I don't pursue my cause of action, my lord, which becomes then barred by limitation. My lord, here what am I doing? I am saying that I have redeemed a mortgage. My lord, a mortgage debt, my lord, remains alive for, my lord, enforcement, either, my lord, by way of, my lord, the enforcing the rights of subrogation or by way of filing of a suit, my lord, for a period of 12 years. That is, my lord, the period for which a mortgage debt remains alive for enforcement. My lord, so far as that is concerned, I have now come forward here to enforce that, my lord. Now, my lord, my learned friends, my lord, here, my lord, have said that they have a claim over my properties. My lord, if you lodge, এখানে আমাদের ওদের statement of claim টা আছে? Statement of claim টা আছে, I know what is a counter claim. Statement of claim টা আছে.
Mr. Chaudhary, why should the trial court not even consider this? He will not even answer the question.
No, our trial court has
Because
considered.
he says that it's not before me, I'll not.
Simple formula. He has two rights. Assume first is whether he has redeemed.
He should see the preliminary decree. When the preliminary decree was passed, the court said that I am postponing decision on these questions to a later stage. Now the later stage has arrived.
Yes.
At the later stage, the question is posed to the court again.
Yes.
That see, you had postponed it.
Yes.
Now the question can be considered. The stage is ripened. Please answer them. Now
Court
the
rejects his
no,
contention.
but the court doesn't say you have not done this.
My lord, may I just show your lordship one sentence from the order?
I'll come to you.
Yes.
Just food for thought for you to
Yes,
reply.
yes.
So far
I
as,
am
my lord,
ready.
the counter claim is concerned, lordship will have to consider it in a conspectus or statement of claim, which is unfortunately not on record. But, my lord, still then, I shall, my lord, try to show your lordship, my lord, what is the counter claim on. My lord, if your lordship will, my lord, kindly give me a moment. My lord, the counter claim is, my lord, here on record, page 109, I believe.
Yes.
109 of the revision.
না revision of the written objection বা আলাদা করে file
Yes.
দেবো
হ্যাঁ আছে আছে Yes, my lord, will please see take page 109 of the written objection.
Page 109 is the DRAT's order.
No,
No, my lord, this is of the written objection.
separately filed.
Not of your revision.
পুরো written objection
এটা কোথায় আছে?
ওদের supplementary.
My lord, this is a part of the supplementary that was filed by Mr. Chaudhary's client.
Yes.
My
Page
lord, please see, my lord,
109.
from paragraph 3, your lordship will get a sense of, my lord, what was the
Page 109 is the arbitrate claim before the arbitrator.
Yes, yes. This is the statement of defense and counterclaim.
Your
Unfortunately,
counterclaim.
unfortunately, lordship will not find the statement of claim on record. But my lord, your lordship will still be able to get a sense of what, my lord, was being defended there. My lord, please see paragraph 3.
Paragraph 3. Yes.
Well, this sets the background. At all material times, the parties hereinafter, for the sake of convenience, referred to the Kejriwal family had been engaged in business of iron and steel. Business comprised of purchasing iron and steel scrap, processing the same, thereafter selling. Respondent number 1, along with claimant and this respondent, formed several companies. Subhadra Trading, Morari Mohan, Subhadra Express, Scrapflow, and Vinay. All the aforesaid businesses were carried from centralized. Ratio of distribution of profit and loss among the parties in Subhadra Trading is as follows. So, my lord, we were at that point of time concerned with Subhadra Trading. Between 75, 76 and 89, 90 profits were partnership firm made considerable profits. Then, my lord, ultimately business, my lord, dwindled, firm was wound up. In view of the disputes and differences, having arisen by and between the claimant and the respondent, on about June 96, my lord, it was decided by the respondent number 1 that the administration and day-to-day activities of Hanuman Foundry, etc., would be looked after by the claimant. This is, my lord, the settlement. Subsequently, paragraph G, respondent also floated
Paragraph
new
G.
company by then. Yes. Well, this is the background. Now, my lord, all that I'm trying to show you, lordship, is, my lord, ultimately, my lord, it is, my lord, with regard to the division of the business that this whole thing was, my lord, filed. Claims were made in respect of, my lord, Subhadra Trading, the business. Now, my lord, there is no doubt that, my lord, today it is the family dwelling house that was, my lord, or the family flats that were mortgaged. My lord, family businesses may take loans. The family flats are mortgaged. And ultimately, my lord, so far as the family flats are concerned, the mortgage is redeemed by an individual or out of the, my lord, proceeds of business. And, my lord, here, if your lordship sees, paragraph M, claimant has deliberately suppressed material particulars, especially with regard to the liabilities of Subhadra Trading to various banks. And then, my lord, the liabilities to the banks, my lord, were, well, let's set out. Then paragraph N, what were the securities, my lord, given are set out. Then, my lord, please see paragraph O. Banks filed original application for debt recovery tribunal. Paragraph P, my lord, steps taken by the PNB. Then, my lord, paragraph Q, my lord, sale of properties to, my lord, meet the bank's debts. Paragraph R, my lord, pendency of proceeding by Indian Bank, mutual settlement was arrived at by virtue of bank agreed to settle. Out of the said settlement amount, my lord, how it is paid. Then, my lord, settlement, my lord, certificate, my lord, recovery certificate, etc., all mentioned. Well, lord, then please see paragraph V. The respondent has thus paid the following amounts towards the claims of the Indian Bank and Punjab National Bank, respectively. Well, lord, DRT, then, my lord, agreed by the order of the DRT, what steps are taken. Then, my lord, will find, my lord, what are the allegations, my lord, in the statement of claim. Paragraph 6, if your lordship sees, well, this concerns the partnership businesses.
Paragraph 18 was placed.
Yes, but, my lord, also see, my lord, the substance of, my lord, this is what was, well, my learned friend should have disclosed the statement of claim also. He, my lord, chooses to, my lord, disclose only the, my lord, counter statement and counter claim. But, my lord, the statement of claim would have given your lordship the true, my lord, the text of the dispute. But, my lord, still, paragraph 6. My lord, the partnership firms of Subhadra Trading as well as other firms like Subhadra Exports, Scrapflow, Morari Mohan Agarwal, Vinayak Steels are accretions of labor and pursuance of the industry of respondent number 2. Although the respondent number 1 and its two sons, that is the claimant and the respondent 2, collectively are referred to as Kejriwal and described as partners, claimant had little or no contribution. In the claimant has little or no contribution. Room numbers 12 on the 5th floor of premise number 12, Netaji Subhash Road, is an asset of Subhadra Trading Company. In the same premises, being premise number 12A, Netaji Subhash Road, Kejriwals have 3 office rooms. Office space bearing room number 2 is owned by Murari Mohan Kejriwal. Room number 2 is now occupied by the claimant. It is known to the claimant that the said office space bearing room number 2 was put up for sale by RC. Reserve price is fixed. Room number 2 had initially been mortgaged. Well, we are talking about the assets of Subhadra Trading. And then, my lord, if your lordship sees, my lord, these are, my lord, discussed in some detail. And then if your lordship sees page 123, my lord, to about 15 lines from the bottom of the page or 12 lines from the bottom of the page, it says, although Shubhadra Trading has been described by the claimant as the respondent of 3, the cause title to the statement of claim does not indicate any respondent styled as Shubhadra Trading. Presently is not engaged in business. Property at Benares Road, Howrah had been sold to meet the dues of the bank. Circumstances under which such sale was conducted has been described more fully elsewhere. Respondent 2 shall refer to at the time of hearing. And then, my lord, please see paragraph 7. These are the disputes. My lord, the dispute was not with regard to redemption of mortgage. My lord, please see ownership of the rooms. Statement of claim, paragraphs 4 to 7 of the statement of claim. This respondent states that it is known to the claimant that room number 2 was and is owned by respondent 1. Room number 4 was in the name of the claimant, and room number 12 was and is owned by Shubhadra Trading. Respondent number 1 had 40% share, claimant had 30% share, respondent had 30% share. However, inasmuch as the business of Kejriwals comprising their father and 2 sons were being jointly run and there was no segregation in the manner as now suggested by the claimant, the 3 office rooms were used by the firms jointly. Claimant never had any exclusive control over the office rooms. Claimant and the respondent used all 3 office rooms jointly for the purpose of conducting business. This is also tacitly admitted. Similarly, the real dispute was with regard to that. And then your lordship will find dispute with regard to Wellcast, that is another my lord company over which my learned friends are asserting right. Then reference to family settlement, other suits filed between the parties, with regard to my lord, this family settlement and control of businesses. This pertains to the control of business. And then, my lord, if your lordship sees the paragraph to which your lordship was referring to, this is the counterclaim paragraph, but the counterclaim is made in the context of what? It is made in the context of the claim that ultimately this is how the assets will have to be divided.
No, I think Mr. Chaudhary was hinting that these payments were payments which you say have been made for the purpose of redemption.
Yes, my lord.
Was that your case, Mr. Chaudhary?
No, that's right. Now, my lord, so far as
of the counterclaim,
distribution of assets is concerned.
You had shown this to show that you are claiming these amounts to have been paid by him for the purpose of redemption. Is what was his case before the arbitrator?
Yes. He said all this. Also expenses he has claimed in arbitration, in another suit
Payments
before
made
the
to
High Court.
bank and all.
Yes,
these are
yes,
there.
he's claimed that.
Expenses I've claimed in another suit. There's no doubt about that. The suit
File
before
apart
your lordship.
from arbitration,
So
another
these
suit.
expenses are other than charges for mortgage money.
No. Please see the plaint. The plaint is now on record. Please see the plaint. The plaint is, my lord, disclosed in our supplementary affidavit. This is CS 377.
Plain page 9 of supplementary.
Supplementary affidavit, page 9.
Page 9. Schedule of expenses.
Page 9 of the supplementary affidavit.
Your supplementary or his?
Yes, my lord.
Your supplementary.
Yes.
At page 33, your lordship will find the schedule of, my lord, what is the subject matter of the claim.
Advocate চিঠি তার তলাতে আছে হঠাৎ এটা page 38 rather. Medical expenses, household expenses, property tax, and this is for a particular
Page 9,
period.
yes.
My lord, please see, my lord, here. But if your lordship will see the first annexure, my lord, to the plaint. The plaint starts there. My lord, the first annexure to the plaint, annexure A, my lord, gives your lordship the particulars of what is being claimed.
Page?
My lord, my lord, please see page 38 once.
Schedule to the
Page 38.
This is the schedule to the plaint.
But we showed also.
Huh?
Schedule B to the plaint. না ওটা প্লেন না তো কৌশিকদার চিঠির শিডিউলটা
না
এইটা this is
my lord, this is page
38 is the
page 33,
schedule to
my
the
lord.
letter issued
Letter,
by
and
the
then 33
Please come
Your
to
letter.
page 30. No.
33
Page number gulo milche.
Mr. Banerjee's letter.
33 page 33
My lord, does your lordship have schedule B at page 33? The page milche na. কতগুলো affidavit কি হয়ে গেছে, এটা মুশকিল হয়ে গেছে না?
না there is another
Page 33.
Right, your injunction
There is
Yes,
a
yes, yes.
Annexure B.
Yes, yes.
Yes, my lord. If your lordship sees that, well, that is, my lord, what is being claimed. Medical expenses, flat maintenance expenses, property tax, municipal rates and taxes, electricity, food and lodging.
And this is elucidated.
Here also same claim.
Same thing.
No, but here he's claiming mortgage money in a
Mortgage.
sense.
Also,
Well, let us see.
both.
Well, let
Please
us
see the claims. I tabulated and showed, my lord.
No, no, my lord, let us read the
No,
plaint.
and-
I don't
and-
mind,
and-
my lord, reading the whole plaint, my lord. I don't mind it at all.
Don't have
But, my lord, so far as this is concerned, this is, my lord, the schedule.
And this is for which period?
And, my lord, also see, my lord, now, please
Which
see, my
period?
lord, paragraphs.
Period to देखते हो.
Paragraph 16, 15 and 16 of the plaint.
So that your lordship doesn't have to hear this, my lord. Property tax, maintenance, etc. is here. And in the arbitration, my lord, there is some expenses and money paid to the bank.
So which according to you is the money which he ought to have claimed?
Yes.
I mean, he has claimed and is in respect of redemption.
Yes. And my lord, he always has a right to make a money claim. Always.
According to my learned friend, I have forfeited that right
No,
because, my lord, the arbitration is in abandon.
No. You have, and you made a money claim in arbitration, you made a money claim in suit. You did not file suit for foreclosure and sale because you occupy, if there is redemption in your favor, you are as if a mortgagee under section 92. If you did not file suit as a mortgage, as if a mortgagee under 92, you cannot stop partition of the
Well,
property.
I have shown your
You
lordship,
can
my
have
lord,
money
Supreme
claim,
Court,
which
says
you have
that, my
made
lord,
in
I
any
stand
case
in the position
abandoned.
of a surety. My lord, surety who steps into the shoes of the mortgagee. My lord, mortgage property cannot be dealt with. My lord, till the mortgage is discharged.
That's why you are as if.
Now, my lord, so far as that is concerned, it is natural. My lord, I don't know, my lord, when my learned friend is opposing and when he is conceding.
No, he's doing both.
Yes, so my lord, that is why.
No, question of law, I wanted to assist.
My lord, he keeps
That's
me in
why
a
I showed
constant state of
contract.
confusion because I don't know whether he's assisting me or assisting himself.
No, I assisted with, I'm used to assisting Mr. Shah. I've appeared in so many matters as his junior. So I was assisting with Contract Act then, but now I am exclusively opposing.
My lord, be that as it may, my lord, ultimately, my lord, two questions, my lord, that survive for my lord consideration now. One is, my lord, whether I have claimed, my lord, the same claims in alternate proceedings. My lord, my first answer to that is, my lord, CS 377 is in respect of, my lord, completely separate subject matter altogether. My lord, there is no crossover so far as this is concerned. So far as, my lord, the arbitration proceeding is concerned, my lord, the arbitration proceeding was in response to, my lord, a claim for, my lord, ultimately, my lord, occupation of, my lord, office spaces of the family businesses. My lord, in the absence of the statement of claim, your lordship cannot really understand the two prospectus of what the dispute before the arbitrator was. But, my lord, the question is, my lord, when both parties, my lord, abandon a forum, and, my lord, they go on agitating their rights in different fora, because, my lord, there are several litigations between the parties with regard to this family settlement, family partition, control of businesses, including, my lord, proceedings before the Company Law Board, which have come up in appeal and now under pending in consideration under Section 10A of the Companies Act, all that is there. So, my lord, there is no abandonment in the context of, my lord, relinquishment of the right. They may not have pursued a right. The question is, my lord, whether in law that will amount to an estoppel. Now, my lord, we talk about estoppel, my lord, when, my lord, it has the effect of depriving another party of a right. My lord, that is the concept of estoppel. My lord, it is the doctrine of fairness. It is the doctrine of equity. My lord, I should not, my lord, by my acts, my lord, give you an impression, my lord, which will ultimately, my lord, compel you to or persuade you to forego another right. My lord, that is the whole concept, estoppel by conduct. I give you, my lord, reason to believe that, my lord, a particular state of affairs is prevailing. So, my lord, I cannot argue to the contrary because, my lord, that would deprive you of a valuable right. My lord, here there is no deprivation of any right. The parties, my lord, file their respective pleadings before the arbitrator. Your lordship will get only one side of the pleadings because the statement of claim is not before your lordship. And ultimately, my lord, they chose not to pursue the arbitrator before the arbitrator, but they have been pursuing, my lord, their remedies before all fora in respect of partition and the same family settlement on which, my lord, this whole thing proceeds. But, my lord, so far as the mortgage is concerned, the redemption of mortgage, my lord, is something that I have done, asserted, not denied. The only denial is if you have done it because it is because you had taken the loan. That will have to be decided. I'm not saying that this will not be decided. But whose loan it was, who was to discharge the debt, whether my learned friend was at all a core mortgager, whether if I step into the shoes of the mortgagee against him as a surety, all these questions will have to be decided. I'm not saying that they don't. But at the end of the day, the question is whether that amounts to my relinquishing the right altogether for all times to come. That is the question. With the greatest respect, there is no such impression that was ever conveyed. Now, because even my learned friend admits that I could have filed a suit. If I have relinquished my right, it is for all times to come. I cannot file a suit or any other proceeding. For foreclosure, for otherwise enforcement of or recovery of money, no. What I do is, if I step into the shoes of a mortgagee in law, and that is the prescription of section 92, in that case, as a mortgagee, I can prevent the transfer of the property until my mortgage debt is discharged. And that is the right I'm seeking to enforce. And that is exactly what section 95 ultimately says. Just kindly once come back to section 92 and 95, and I shall end with that. I don't want to keep on arguing the same thing. Please see, ultimately, section 92 is, the section which, gives me the right of subrogation.
With Krishna Pillai, the same line. Krishna Krishna. Subject to
এটা কোথায় বলেছে?
Krishna Krishna.
এটা ওরা দেখিয়েছিল তো? I think I'll just show you lordship another paragraph, but first let me just show 92 is the empowering section, and then please see 95, where one of the several mortgagors redeems the mortgage property. He shall, in enforcing his right in subrogation under 92 against his co-mortgagors, be entitled to add to the mortgage money recoverable from them such portion of the expenses in redemption as is attributable. So, I can recover it. Now, for recovery, the first question is, let us say I do not, proceed to recover immediately. My charge, does not vanish because the charge is created by section 92. As soon as I exercise my right of subrogation, what is the nature? What is the effect? Section 92 say I step into the shoes of the mortgagee. As soon as I step into the shoes of the mortgagee, I assume a charge over the property. If I assume a charge over the property, the question is, do I have to go to court and file a suit? Or can I say that so long as my charge subsists and my mortgage claim is not barred by limitation, you cannot deal with the property. That is the ratio. And just one paragraph that my juniors say that I should show you lordship from the judgment. That is the decision in 2004 volume 12 SCC 754 that I handed up to your lordship earlier.
21.
One paragraph to
21.
20. It kindly allows me to show paragraph 17 first. 17, 21, 22.
Note take it mean 21 time in.
May I show 21?
Now I am better at assisting than your junior in the
2004-12
from school.
21. The present case, 2004-12. SCC page 754.
21 time, Lord.
21 you have placed.
Yes. This is the ratio.
This is the ratio.
This is what happens. Rights akin to those vesting in the mortgage. Now, if the right akin to the vesting of the mortgage is the principle on which we have to proceed. The mortgage property cannot be dealt with till the mortgage debt is discharged. And that is the whole ratio of this judgment. And all the judgments speak in the same voice. That your right of subrogation will survive so long as the mortgage debt is not discharged. Well, does that mean that I have to immediately rush to court to file a suit? My charge will not vanish. If I don't file a suit, will my charge go away?
That's 21.
And now, my lord, when my learned friend wants to, my lord, ultimately seek partition, then what do I say? That ultimately, my lord, please get yourself discharged of this charge by, my lord, ultimately agreeing to an OLT situation, or, my lord, in such circumstances, are not equitable division of the property according to your share. Because this, my lord, debt will have to be accounted for. And that is, my lord, all that there is. Well, these are my submissions. Well, the note, my lord, has a few typographical errors. I'll just correct
Mr. Chaudhary, I'll keep it next Friday again. I may have some, I'll hear you also on that day.
What I'll do is I'll file my note on Monday, so that
Then
your
you
lordship
file it on Friday itself. On that day itself, conclude it. I will also, because there are a lot of papers now, two supplementary.
May I just have 30 seconds
Yes,
to
of course.
give a structure so that when your lordship reads the whole.
No, I have it in my mind.
Yes,
I have it in my mind.
Just 30 seconds.
Yes, I just want to get it clarified. If something else comes after you complete your hearing.
Yes. Just 3 points I have made. I written down while Mr. Shah was arguing. Number one, no redemption. No document on record. Payment made is irrelevant since there is no redemption, insofar as a claim in the property to prevent partition is concerned. Number two, alternatively, if there is redemption, two rights. One under section 92 to file a suit for foreclosure and sale, not done. Second, to make a money claim, done. Combine two proceedings. Number one, suit. Number two, arbitration. In suit, expenses. In arbitration, to a payment made to banks. Already done. They can, and Milord, so it can't be redone again somewhere else. Learned Judge Milord of the learned court below, on the ground that he has filed other proceedings, has rejected this application.
Well, I'll do something. Well, instead of filing the note today, since your lordship is keeping it next Friday, on the point of estoppel that your lordship is saying that, my lord, I've relinquished the right, waiver.
That is his argument precisely.
Well, that point, my lord, no, my lord, that point I'll deal with.
And money can't stop partition.
What I will do is, my lord, I will, my lord, also, my lord, include the
He's saying
statement.
that only. He says that you have claimed a part of it in the civil suit that you have filed here in the High Court. The other part you have claimed before the arbitrator. You cannot claim it again before.
That's what learned judge says. You go take leave of High Court.
My lord, he is arguing at 6s and 7s because he himself said you could have filed a money suit.
I don't want to.
No.
I am asking for, can you block a suit for partition of a property by having a money claim on me?
To the extent that you seek to take away the mortgage asset.
Answer is in Krishna Pillai. Grateful.
The answer is in Krishna Pillai, 2004-12 Supreme Court case. I'll just modify the note a little and file it, my lord, either next Friday or Monday whenever you lodge.
Mr. Saha, that advocate appearing for the petition. Next Friday?
Yes.
Next. List this matter once again as jointly suggested by the party on August 28, 2026 at 2 p.m. Ashwata.
This is Lordship will kindly is that this is an asset-based search. Lordship has got it. The first 2 pages, asset-based search. Lordship will kindly sees the page where the printout is horizontal. Lordship has got it. Lordship will see the second page shows not only my charge, possibly all the flats also.
Yes, Mr. Mukherjee.
Now, Lordship will kindly look into
Yes.
the entry 5, Lordship.
I have just my learned friend downloaded. It still shows no entry.
Lordship will
But
see.
they are showing this. How will I disbelieve this also?
Lordship will now
This is
kindly.
there here.
Lordship will see the 5th entry. Now, this is the downloaded part of the 5th entry is my entry.
And
this is the downloaded portion of the 5th entry.
and here also that
It is
the
MP, but Lordship will look into the other entries, MA. It is all the other entries are showing. So according to them, they have taken loan and they have purchased that. Then therefore, there is a security which is created. And possibly these are the tertiary entries which are
These are questions which need to be gone before the DRT only.
And Lordship will kindly see the next.
My lord, in my humble submission, DRT will not be able to go into this question.
How will I go into
Lordship,
this?
Lordship
Definitely
kindly
DRT.
allows me
These
to
are
30
factual
seconds.
questions.
30 seconds, man. 30 seconds. Lordship will kindly consider that here are the writ petitioners who have approached this honorable court because
Lordship, this is repetition. You have said that in the morning. This is not an
Lordship has
addition.
not heard me. Even the last sentence, Lordship couldn't allow me to continue.
Because you are repeating the last.
No, I am
sentence.
not repeating.
Go on,
Lordship.
let us see how long you.
No,
can
no,
continue.
Lordship passes the order, whatever Lordship
Continue.
deems fit.
Please continue. Since you still show dissatisfaction, you please continue. Then I will also stop. Let us see how long we can sit together.
Lordship, pass the order.
No, you please complete.
Whatever I was saying, that Lordship can entertain a writ petition in certain circumstances. One of the circumstances is when my fundamental right is violated. My learned friend's client, the State Bank, has approached the CMM's court in 2015. They got the order in 2019. So 4 years, no progress. From 2019 to 2026, no progress. Then they come and get an order from your lordship. They do not do anything till the borrower and the guarantor was there in the property. The moment they go out of the property, they start their action. Secondly, as a purchaser of a property, what more I could have done? I have taken loan, I have made searches, and the search still shows. Just 5 minutes back, it has been downloaded. After paying necessary charges, it still shows there is no charge. So in my humble submission, this writ petition can be entertained.
PHR invent I'm carrying with on the point of maintainability. No exceptional case under PHR invent has been made out. And lordship, the judgment lordship had the Mangaldas Rajendra Kamthe is also lordship. 37 and 38 of PHR invent is very clear now. No exceptional case has been made out, lordship. Prima facie, their title is bad. They are claiming title based on their vendor's title in 2016. My 13.2 is in 2014.
My vendor is not the borrower, neither the guarantor. And kindly see the notice which they have given on 13th. Everything is immaterial in SURFACE Act. In 2013, on 13th August, the notice which they have given, they have not addressed the notice to me. The writ petition they filed, I am not a party to that writ petition. They're obtaining orders completely suppressing my existence.
How will you be a party to the writ petition, Mr. Mukherjee? You are not the borrower. How will you be a party?
My lord, in my humble submission, will it not be incumbent upon the bank to have a due diligence on the property?
No, it's not the. It's not.
Lordship kindly holds that then.
Yes.
That it is that due diligence.
Judgments. Please read Ram Tarle's judgment. You, Mr. Mukherjee, you are making submissions as if you are unaware of the law. You know the law, still you are going on making these submissions.
But when they're filing,
You are unnecessarily putting duties which are not there on the creditor. The creditor is not supposed to go to the property and see who are there in the property and issue notices in all their names, make all of them party. A litigation will never end with this. That is not the situation in law. That is not the statement of law. And you are aware of this. Still you want me to hear this and pass an order.
my lord, kindly considers that we made, in fact, the bank from whom I got my loans, they made the searches. They made the searches. As an ordinary person of prudence, what more do I do? I'm asking myself.
The other entries are also possibly
Yes,
with respect to flats.
that-
Now their search
That shows that mortgages have been done for individual flats, and this mortgage would not have been possible if the bank's mortgage on the overall property was visible.
that is visible, Lordship, it's still appearing with that same typographical error in the same page. And
It is visible now.
detail
Was
of
it
the
visible contemporaneously?
detail of that my entry, I have separately printed that. That is also before your Lordship. Lordship will
No prudent person will invest so much. 40 lakhs, 50 lakhs, 30 lakhs, 35 lakhs.
Lordship will see
Individually, hard-earned money.
fifth entry is the entry which is the State Bank's entry, and Lordship will take the second page. Lordship will kindly see the same asset ID number, and Lordship will see that this typographical error is appearing. Similarly with all the other entries, and this is an asset-based search.
In the asset, what was the number mentioned? 32.
32.
But plot number 32A.
Yes, 32, 32A. Lordship will kindly take the first page of the horizontal page, and also the Lordship has got the pages which are horizontal. Yes. 32 Mahendra Shrimani, 32A is also mentioned. And Lordship, even if I take their submissions that they have mortgaged it to the bank, then there are tertiary registrations, and that is showing.
Yes, that is exactly what is my point.
But what they are furnishing, not a single entry they say is there against this property.
His name is appearing because there is a loan operating against him.
That's what I'm saying, na.
All the entries are appearing in the same page. And when I want to open that, I have to download that portion. That downloaded portion is what has been also handed over to
Bank waits for 11 years and they cannot wait for 11 days.
These are not a matter of waiting for 11
What
days.
did they do for 2015 to 2019 before the CMM's court?
I don't think
before my
this senior friend's client has any locus to question that.
That is visible. না দর্শক দেখতে চাইছেন না তো আমি কি করবো?
আপনাদের কেউ সার্সাই রেজিস্ট্রেশন নেই, এটাই তো হয়ে যাচ্ছে সবকটা তো এখানে দেখা
100 crore, they are saying there's a 100 crore due. If I may ask myself, what did the bank do?
Asset-based search is a little defective. Kindly come to the first page.
Yes.
See the search criteria mentioned.
My search criteria.
Yes, please wait for the quote. Have some patience. Now I have heard you. Now kindly patiently hear the quote also. Asset category, immovable, right? I am expecting an answer from you, Mr. Mukherjee. Right? Next, type of asset, residential. Description of asset, blank. Survey number, municipal number is blank in yours. Bank writes 32 Mahendra Simani and then writes plot 32A. You have written plot 32A. On top of that, there is blank and the result is nil. The result is nil. With this, the result comes.
Kindly cease.
Whether it
Kindly
is a-
cease now.
whether
Kindly
it-
cease now. Filling up everything.
Show me.
Taken out just while we were in the court.
Here again, you have just written 32A. Survey number, municipal number is not 32A, it is 32. Plot number is 32A.
We have filled up whatever bank has filled and
No,
giving
you
that.
haven't. You haven't. You have just filled the opposite. Please match it again. You are again making submission without matching your own records. Please match it again. Instead of 32, you have
Lordship, sir.
32A. Survey
Description.
number, municipal number, what have you mentioned?
32 হবে আর এটা 32
Unit number 32A.
Sir, survey number, municipal number is 32, plot number is 32A.
My plot is what they are trying to kindly seize their notice. It is 32A.
They have also written 32A. That is plot number.
So I do not have to
plot
put
number.
in 32.
That is what has been put. And that is how the result comes, and which is different from your result because you haven't put that.
My lord,
that is why.
my
that is
lord,
why
a
this is-
layman who purchases
These
the
are all
property.
submissions. These won't fall within one of the 4 exceptions which you noted. This. Read it with me.
Paragraph
a
six.
parting observation.
Paragraph
Paragraph 4 first. Then paragraph 6. A
Right.
parting observation seems to be necessary
That
considering
is what
the
is-
contents of the order.
Yes.
And thereafter kindly see.
Paragraph 6 says it is settled law that once High Court upon application of mine declines to entertain a writ petition in
On
the
what ground?
in
On
the
what
ex-
ground?
in the exercise of discretionary jurisdiction on the ground that an efficacious alternative
That is
remedy for
exactly what I'm going to do. I'm going to relegate you to the DRT because I feel it is effective. I feel that I cannot enter into it. These are disputed questions of fact.
Therefore, that's what I'm saying. I am unable to explain to Lordship, that is my failure, that efficacious remedy of petitioners lies here only.
It doesn't. It would
Because the
have
bank's
you
own
would have said
conduct.
So if you'd have, if you know,
Bank's own conduct
Mr.
gives
Mr.
rise to this
Mr.
violation of
Mukherjee, your
fundamental right.
submission- Your submission would be tenable only in 4 cases
Yes.
where there is an enforcement of fundamental right,
Right.
which is not your case. It's a right to property and not Article 21. So you go out of that.
No.
Yes, definitely yes. Next, it's not a question of challenge of viris, so therefore it goes out of that. Third, not a question of violation of natural justice.
Violation of, yes, I am in that.
Let me complete. Section 14 is not an authority where you are required to be heard. You are not the borrower. You are not the guarantor. If you have any remedy, you come within the wide bracket of any person aggrieved under Section 17 of the SURFACE Act. So this third bracket also closed. Fourth is the other limb.
The other,
None of them.
my lord, in my humble submission, the mere existence of alternative
You can
remedy.
go on till 4:30, Mr. Mukherjee. It's
Lordship passes the order. And I